Boom. Hey, folks. Sorry about that. I feel like I've robbed you of a bunch of time that we, pardon the pun. Rob will forgive me for that. How is everyone doing? Today's been a chaotic day on my end, and yeah. Sorry about being late. I really do apologize for that. I will say I was off doing research and it turned into a bit more of a rabbit hole than I thought it would. I am researching an issue that'll probably be for both this this channel, but also the Role of Law channel. I'm probably going to roll it on both. It is about Magic the Gathering. Which some of you are interested in and some of you are tuning out. But I needed to get some information, so I went to meet with an expert on the subject, and he turned out to be super fascinating, and super knowledgeable, and things were longer than I expected. So that is why I had to push things back, and that is why I am late. So, I'm glad you guys are all here. I was just like, there's so much to talk about. I gotta go live because there's just so many things. Now, I hope that those of you who are looking, I see a lot of you are mentioning that you got a storm coming. I hope you guys are all doing okay. I hope everything is. I'm worried about everybody because it's chaos. So yeah, I hope everyone is doing all right. I hope people, and if you're not in a safe place, please don't watch. Please get to a safe place, because I feel like that is the most important thing. So yeah. All right. Now I see I put up a poll. The poll was for what should we start with. I am going to end that poll, but the current winner is Hannah, followed by Karen Reed, followed by Diddy, followed by Eric Adams. So not necessarily what I expected, but it's a perfectly viable order of things. And guys, I know Lawyer was in the path of everything. I did see that he mentioned that he was going to be like basically taking precautions. So I'm not super worried about him. Just because I think he is probably really well positioned to be safe. But I hope I'm gonna handle this. Look how he holds that Coke can like they're a sponsor. No, but we can talk a little side note there. Coke actually specifically designs it so that when you hold it so that the drink is aimed in your direction, that it shows it off. So yeah. Yeah. Ask the Quartering about Magic the Gathering. He's a little far away. Crystal says, Runkle, trying to buy your hot sauce, but the membership code isn't populating. Is this a known issue? The membership code should work off the link. You're the first person who's told me that that's an issue. But if not, you can, that link includes the membership code, so you can break it apart. So if you're having trouble, shoot me a message, because I do want to help the members get to my hot sauce first. I guess we can talk about the hot sauce. Yeah, let's talk about the hot sauce. So I am, as you probably know, I am selling a hot sauce. And the hot sauce is, this is one of the two hot sauces. The other one is Everyone Makes Mistakes. Somebody's asking, is it Canada only? It is Canada only. It is Canada only for this one. I can't stop you from getting it to ship to a Canadian and then send it on your way, but I can't send it to you directly. And that was my Windows that beeped. So, because I've got the audio piped through so that we can watch Hannah. So, the hot sauce is now at long last for sale. It's at long last for sale. Now, I have set the hot sauce as a special member pre-order. So what does that mean? Well, it means that right now, if you go to the shop, you will see an insane price. You will see an absolutely stupid price. And I will show you the stupid price because the stupid price is stupid. So this is the stupid. Whoop, no, I gotta there. This is the stupid price. It's $100, right? It's $100. However, the $100, if you have a membership, and that's a membership here or a membership on Patreon, like if you're a paying person on Patreon, or if you're a paying person on Locals, you will have access to a code that gives you 75% off, which takes it down to the more reasonable price of $25 Canadian. So $25 Canadian is high, but that's what we're stuck with because it's a small batch thing. So it is what it is. So the at the end of 2 weeks, that code will expire. That code's gonna run out. And so when that code runs out, the price is going to drop down to $25 Canadian for everybody. So basically, if it hasn't sold out in 2 weeks, Mike is. All right, hopefully you can hear me again. I don't know what the mic problem is. Which one is the spicy one? Is everyone makes mistakes, and the really spicy one is burn your regrets. So, yeah, that's basically the long and short of it. Is that now this hot sauce is oh, are people able to hear me? Okay, I see 5x5. Good. This particular hot sauce is ultimately basically the purpose of it, or where it came from, is that somebody reached out and said, hey, a friend of mine is getting into doing fermenting. And I went, cool, that is awesome. But so I reached out and I was like, I would like to make a hot sauce. Somebody's saying check for crackles again. I have got a problem. So I narrowed down the problem. I hope the crackling is gone. I hope. The problem that with the audio is NVIDIA installs its own audio drivers for some freaking reason, and they suck. So they are messing me up. But yeah. So anyway, this hot sauce, I do finally. I bought a label maker. I bought a label printer thing. And yeah, I haven't tested it out yet. It's got a plug, it's got a thing, it's got all the things. I haven't tested it out yet, but I am hoping that I can use this to print out all the labels, because otherwise I was going to have to cut them out by hand, and that was going to suck. And I just, I don't want to be there. I don't want to live that life because that would be miserable. So, I'm hopeful that this label maker thing is going to make my life so much easier. So much easier. All right. Now we have a ton of things to cover that aren't just my hot sauce, that aren't just, that. But the hot sauce is something that I'm super excited about. I'm super thrilled by. And I'm also terrified. The reason why I'm terrified is that I really want people to like this. I really don't want people to be like, I bought your hot sauce and it sucks. What's wrong with you, Runkle? If that happens, I guess I'll be issuing refunds and taking a giant bath on the costs of all this. And the other thing is people are saying, how much of your hot sauce do you need to sell to break even? Basically the entire batch. Basically the entire batch of hot sauce in order to break even. And the reason why is because there's all sorts of expenses and some of them you don't really expect. So I'm not going to be like rolling in money after all of this. It just is what it is. So I'm going to plug this in. Give me 1 second if I can do it without dying. And yes, Tide, I see you. Give me 1 second. I'm going to plug in the label maker in. We'll see if we can have a test print. We'll see if that is something that we can do with this. Oh, wait, that's probably going to be it's probably going to be a production. I don't know. I've still plugged it in. We'll play around maybe as we go. All right. So, the thing is that I'm not going to make, I don't think I'm going to make money on this batch. But I might make some on the next batch. And especially because if I get the next batch with, if I'm able to sell in the US, then I can do a little bit more, I can be like, there's more of you in the US and just stuff like that, right? So, although shipping might suck. So, that is kind of where we're at there. All right. Now, and I'm not going to be a hot sauce millionaire. I just want to, the real thing is that I love this hot sauce. And I want to share it with you guys. I just really want to, I hope you guys love it as much as I do, right? I just, that's my hope. So, all right, let's jump to our first issue here, which is the Hannah Gutierrez-Reed trial. And yes, it is not from New York City. It is manufactured and made and all of that stuff right here in Alberta. Okay. So what's happening with Hannah Gutierrez-Reed? Well, Baldwin got his charges thrown out. Baldwin's charges were thrown out. And so because of that, Bowles is now going, Lord, I see what you've done for others, and I want you to do that for me. He's saying, hey, I really want to get these charges thrown out for Hannah as well. And so the problem is that Bowles is not in the same situation as Hannah is. And there's a few major differences. One of the major differences is that Bowles was there and was offered to look at these, Teskey rounds and declined to use them for trial and basically sent everyone home. So Bowles isn't really able to say, I didn't know the Teskey rounds existed. I didn't know what was going on, because he did. He's in a very different spot. So what he is going to end up doing is he's going to throw a lot of shit at Carrie Morrissey and basically say Carrie Morrissey is shitty And because she's such a bad person, you should throw this out. Now, there's some other disclosure issues as well. We can talk about those, but he's largely going to be saying Carrie Morrissey is such a terrible person, so awful, that this should be thrown out and, basically throw this into the sun and off we go. Now, yeah, we'll talk about that. Bowles is not necessarily, his argument isn't the best, right? He doesn't have the greatest argument. But I can also tell you, he doesn't have the shittiest argument either. And so Bowles is, not necessarily, I don't think he's necessarily going to win. I also don't think he's necessarily going to lose. And we'll talk about the result of what happens today, because what happens today is kind of exciting and interesting and all of that. And I'm playing with this thing. Where did my power cable? It plopped out. Okay. So, and you will have heard a beep, beep. Static again? Jeez. Why? Restart. Okay, there we go. Hopefully that is better. Yeah, the thing is, putting the rounds under another case number isn't great, but the problem that he's got is he knew those rounds existed, and he's going to have a hard end. Morrissey actually did tell him that those rounds were there, so on that, he is in a much worse position overall. All right, so let us have a look at this. Let's watch this proceeding. We're going to take it up to, I'm just going to say 1 1/4. We're not going to go super fast, but we're going to go a little faster. And so we're going to watch this here. I'm just going to pull it up. I can biggen myself a little bit. We're going to put the subtitles up here and we're going to watch. Okay.
Party, state their name.
Carrie Morrissey on behalf of the state of New Mexico.
I'm going to shrink myself a little bit.
Your Honor, Jason Bowles with Ms. Gutierrez-Reed.
Okay. Let's see.
The audio
All right, so
was
what
crackling a little bit
we should
for
do
me
is start
too.
with the second motion, the more substantive motion, and then go into the other motion.
Yes, Your Honor.
All right, I'm prepared. Go ahead.
Thank you, Your Honor. And so just to clarify, Judge, you want me to argue the motion for new trial or for dismissal first?
That's
No,
what she
no,
just,
not the release one. Okay.
Okay. Yes, Your Honor.
that's what she just said. Yeah, she's like, hey, let's hear the, let's hear this first. And, yeah. Okay. So great. Fantastic. But, I thought it was kind of funny that, it was like, he doesn't know, he's like, which is the more substantive one. I'm like, okay. All right. So here we go.
Right. That's what I thought. Okay. Thank you, Judge. Judge, on July 31st, 2024 of this year, this court filed an opinion in the Baldwin case, and this followed a July 12th hearing in that case. In paragraphs 59 and 60, this court went through the findings of the state's egregious discovery violations, deliberate and intentional withholding of evidence, and in the court's inherent power, stated that dismissal with prejudice was warranted to ensure the integrity of the judicial system.
Here's the thing. She did do all of those things, right? The problem that he's going to run into here is the issue that all of those things happened in a different trial. Those things happened in the Baldwin trial. And his client is not Alec Baldwin. And the reason why that's a problem for him is that he needs to connect this to his client, right? You can't say, oh, the police did some really bad things or the prosecutor did some really bad things in this case that isn't your case. You have to connect it to your client. And this might be where he runs into problems and where he has some difficulties, because I want to see him connect it to his client, right? So let's see how he manages there. Okay.
Now, part of the court's findings, and I'm going to relate them to this case, part of the court's findings also included that Ms. Morrissey, when she testified, called herself as a witness in that hearing on July 12th. Her testimony was inconsistent internally. Her testimony also conflicted with at least one other witness. Now, we have since supplied this court with affidavits from her former co-counsel, Erlinda Johnson, to highlight additional.
Spoiler. Spoiler. There's going to be an issue here. Now, one of the things I thought was kind of funny is I see a lot of you in the chat commenting on it. The picture in the background. Now, at first, I thought that picture was a bad, like that his his camera angle is bad, but I don't think it's his camera angle. I think his picture is actually crooked, because it's that or Bowles is sitting like at a serious angle. Maybe we've got angled Bowles, and but I kind of think that maybe he swapped this picture in. And yeah, you will have heard that. I'm trying to get my printer running here, this new printer. I'm wondering if maybe he if I think he's watching oh, I see people saying static. Christ on a all right, hopefully that's so a lot of us commented about how bad his other picture was. A lot of us commented about how his other picture how do I put this? His other picture looked like a hat, right? And because it had this like steeple, so it looked like he was wearing this stupid hat. And so I think he might have actually watched the I think he was actually watching that, and he took down that painting, like that picture, and put up this other one. And I think he just hasn't leveled it out. That's my theory on that one. So, but I do like that he's no longer wearing what very much looked like a dunce cap in all of the in all of these videos, because it made him look stupid, right? And the thing is you don't ever want to look dumb to the court, right? You don't ever want to. And so this is one of the reasons why lawyers tend to make fairly they tend to make fairly what do you call it, conventional fashion choices. I will say my hair is maybe a bit more of a brave fashion choice than it should be. And that's unfortunate. Emily, love Emily's look. Emily's got a great look. She looks like a person who's living her best life and is having a great time. Emily, I don't think could look like Emily back when she was a prosecutor, right? I just don't think that she could do it. So, that is, that's kind of a whole thing, right? Oop, my computer is now doing things. It is now fighting with me. Okay. So I think that there is some real potential for, I think there's some real potential for, for issues there. Now, the thing is that, he is dressed fairly conventionally, right? He's dressed like a fairly normal person, but you look like an idiot if you are in court, looking like you've got a dunce cap on, right? So good choice. Getting rid of that picture was a good choice. The other thing I will tell you is that when I appear on Zoom court, a lot of the time, I hit the filter. There's a filter that makes your background blurry. And you know why I hit that filter? Well, let's count the ways I need that filter. A, Rob's tie. You guys all know what that means, but to like a judge, it just looks weird. This picture, I love this picture, but it's obviously a rifle. Some judges don't like that you have a giant picture of a rifle behind you. I've got the Rob jury. I've got the secret McSquirrel. I've got all the things behind me, right? And I love all those things. I love all the like little bits and bobs and so forth. But the judge doesn't need to see them, right? So yeah, you got to think about that stuff, and it might feel stupid, right? It might be like, oh, well, why do you know, and the reason why you got to do it is because it matters, right? Is because it matters. Woohoo! So chat, I am going to hold my thumb up so that you can't see all of this, because I just did a cool thing. This is the first shipping label. It works. I got a shipping label out of this. Devin, if you're in the chat, I have printed a shipping label for this. So awesome. All right, so let's go back to what he's doing here.
We believe false testimony that Ms. Morrissey gave to the court. Now, that's important because I think this court has to view through the prism of the prior findings of the affidavits, the comments Ms. Morrissey is making, and what I consider to be shade on the truth on her statements.
Shade on the truth is an interesting way of putting it, right? Because you know what your average bear would say here? Your average bear would just come out and say, she lied, right? She lied. And he doesn't want to say she lied. And fair enough, he doesn't want to say it. I get it. That is fine, right? But the reason why you don't want to say that she lied is that is the kind of thing that is that's a gun that you pull very, very reluctantly. Very, very reluctantly. And I will say, I'll tell this story. I was out and I was, I'm there doing court stuff, and I'm doing a bail hearing. And one of the things I tell the court as part of the bail hearing, why I'm saying that that my client should get out, I say, listen, my client, you know, he's not going to be committing further crimes because he's got a job, and I've been able to speak to his employer and confirm that he's got a job, right? So I said, I talked to the employer. I have confirmed that he has a job. And this Crown prosecutor, who was being an absolute sack of crap doing this, said, well, how do we know that the client actually has a job? All we have is Mr. Runkle's say so. And I get up to respond to that, and the judge is like, Mr. Runkle, sit down. She literally says, Mr. Runkle, sit down. I've got this. And this judge, she's now a Queen's Bench justice, but yeah, this justice says, like, listen, or she was a judge at the time. She says, hey, do you have any evidence that Mr. Runkle is lying here? And the judge is like, oh yeah, I suppose it would be King's Bench now, but and he's like, well, no, but we don't have any evidence that he's telling the truth. And she's like, well, Mr. Runkle is an officer of the court, and he has a good reputation in my court. So if you want to suggest that he might be lying, you had better bring some actual evidence of this, because I will not she's like, she just is like, no, you will not do this. And she ripped into him. Like, you do not do this in my court. So, yep, that is part of why Bowles here is being cautious. And the thing is if there was ever a time when he probably could have gotten away with she lied in court, Bowles is in that scenario. Bowles is in the place where I would actually have said lied. And you know who did say lied? Spiro. Repeatedly. Spiro repeatedly said lied. And not only did he say that she lied in court, he said she then lied about why she lied. He went all the things there. So Spiro could have gone hard, or sorry, Bowles could have gone harder here, but I will not fault him for the caution.
Now, part of the court's findings at paragraph 10 in Baldwin's case included that the state had continuously made late disclosures, and that the state had filed a certification, specifically had certified that she had supplied all of the evidence required under the rules under 5-501. Now, that same thing occurred in this case. And Your Honor, post-trial, we have now learned that Ms. Morrissey never disclosed to us. And
I hope the mic is now better. I'm going to have to keep fighting with it.
Report from August 31st, the Seth Kinney interview that I've highlighted in the motion, and the third one are these Teskey rounds. And I'm going to explain that in a little more detail as well. Now, the same thing the court found in paragraph 10 applies here. The state made that certification, and it was untrue. Your Honor also found in paragraphs 27 and 28 that officer that CST Popple that testified in Ms. Gutierrez-Reed trial had lied, had given false testimony in Baldwin's trial. Specifically, there was a interchange between Ms. Morrissey and Ms. Popple, in which the idea came up in testimony before the jury that these rounds were not similar. The Teskey rounds were not similar to the rounds found in the rest set. The court then held a hearing on July 12th and actually ordered those rounds produced. And despite Ms. Morrissey's continued assertions to me, to the jury, and also part of her testimony that they were not similar, there were three very similar or identical rounds, Starline brass with silver primers. Now,
so the problem that he's going to have here is that he had this stuff. Now, I see people noting that they're still getting audio crackling. Some of that is because this is a recording of a Zoom meeting, and the audio wasn't great from the original. So that stuff we're just stuck with. So I see the signal is too hot and it's distorting. Okay, I can try to turn this down. I don't think I can turn that down. We'll see.
As part of that aftermath, Corporal Hancock testified that Ms. Morrissey was part of the meeting to what I consider to be bury and hide the Teskey rounds that were turned in on March 6th in a separate case file under a separate number. Now, Ms. Morrissey stated that she didn't, the first time she saw these rounds was July 12th. Then the court asked a question during that hearing to Corporal Hancock. Corporal, was Ms. Morrissey present in the meeting to put those rounds in a different case file under a different number? And she said,
all of this is the wrong trial. This is the problem, is all of this is the wrong freaking trial. He needs to get to his issue. He needs to get to, and the thing is Bowles, he's got some good points, but I would really, if I was Bowles, start with the issues of the, start with the issues around his specific trial, and then I would go from his trial and say, and it's especially egregious because of the stuff that happened in the Baldwin trial as well. But right now, Bowles is actually on his A game. This is, Bowles is actually doing better than he's ever done before. And I would have given him top marks. Top marks for this. But I got to deduct. I got to deduct points, and not just a couple of points. Oh, we're going to talk about Bowles. We're going to talk about Bowles so bad. So bad.
Said, yes, she was. Well, and that's part of the court's findings in this court's order, that Miss Morrissey was part of the decision to hide those rounds, hide the supplemental report, and to not have that produced. Now, in Mr. Baldwin's case, the standard, as this court notes in paragraph 48, was evidence disclosed within a trial. Ours is obviously the standard post-trial. And so this court delineates that standard and how it's different for post-trial discovery of evidence. Now, that is that we have to show that there was a reasonable probability that the outcome would be different. And I'm going to get into that with each of our pieces of evidence. Judge, the fact of the matter is, we would have never discovered the Teskey supplemental report or what they had done with that if Baldwin's case had not occurred, if they had not done those interviews. We would have also not discovered the Hague August 31st report, because those came out in Baldwin's interviews in that subsequent case. Those were never turned over, as was Seth Kinney's. So they were all suppressed. Now, were they favorable?
Sir, you had Teskey on your witness list, and you sent him home. So you, like, the Teskey, the thing is that the Teskey rounds are what got Baldwin's trial thrown out. But his problem is he literally had Teskey on his witness list. And so, like, sir. And the problem is all of this is such a shit show. Because at this point, Bowles has always been struggling as a lawyer in this matter. Always. And what I mean by that is from the very beginning, his first moment on this file, where from the very, very first moment, he was doing badly. And what I mean is, you see him in the police interview, and I want to use that police interview to teach young lawyers, like young law students, what not to do in a criminal case, because he is like, that was just so bad. And then during trial, there were moments when he was good, and there were moments when I was just like raging at the screen, because there were points. There was a point where he got the he had the witness lined up, and I'm like, you got him on the ropes, hit him in this cross. And he just never did. He's like, I'm done. And I'm like, no, hit him. Not literally hit him, but like, get him on the cross. And he doesn't. And so now he's doing better, and he's doing worse. And
the court finds, as part of its order in the July 31st order, that there the defense had outlined a progressive trail of how the rounds got from Troy Teskey to the set of Rust. And that was in paragraph 30 of this court's order. The court went through how they went from Teskey to Seth Kinney, they went to the 1883 set, and how they ended up on October 12th being given to Sarah Zachary. Now, the court also said that any additional information as to the source of live rounds or how they arrived on set would likely affect the jury's determination as to proximate cause and as to negligence of third parties under 14-251 UJI. Now, it is the same thing in Miss Gutierrez-Reed's case, but
the problem that Bowles has is really that everything that goes wrong still points to Bowles, or not to Bowles, to Hannah. Let me explain how I mean. He's going to say, listen, this gun was defective. He's like, there's this gun on set. You can see this is obviously not a real gun. YouTube, don't freak out. but they're going to say, like, there's this gun on set and it goes off when you just hiccup at it. You're like, you burp at the gun and it goes bang, right? The problem is that whose problem is it if there's a shitty gun on the set? Hannah's problem. Hannah's the guy who, brings that gun and gives it over to Baldwin and is like, yeah, you can use this. And if the gun is broken, if the gun is crappy, then that's the fault of the armorer who shouldn't be allowing a crappy gun on the set. Like a crappy gun that goes off, at any point. So, yeah, that's kind of our first problem here. The second problem is, let's assume that some evil gremlin brings live rounds on the set, right? And brings live rounds on the set and puts them on her cart, mixes them in with her stuff, right? Intentionally is somebody just wants to see somebody die. I can tell you that the armorers I have spoken to, and I've spoken to a number of armorers, have basically said, even in that case, the armorer should catch it, because armorers have to check every round. And there was an example given. On one stream, they mentioned that they were filming on a military base, right? And they're filming on this military base because they're doing a military movie, and they want to show that, they want it to be realistic, right? So they're filming on this military base. Well, what do they use on military bases? They use live rounds, right? Military bases use actual live rounds. Because of course they do, right? They're the actual military. They don't have dummies. They don't have blanks, I don't think. Actually, they do have use for blanks. So I was wrong about that. They will have blanks on a military base, but that's its own. So they're in the middle of filming, and they find live ammo on set. How do they find live ammo on set? Well, they find live ammo on set because they are careful and because they are diligent. All of the things that Hannah wasn't. And what did they do when they found live ammo on set? What did they do? Well, they stopped. They stopped. They went and inventoried everything that they were dealing with. Every single thing that they were dealing with. And they swept the base to make sure there was no further live ammo. And yeah. And I see people saying that the military has no use for blanks. They do. And I've actually played with some of the military equipment that they use blanks for. This. Side note. I got to play with this. It was super freaking cool. So the U.S. military uses a system. I forget what it's called, but this system basically uses blanks along with lasers, and it can tell you whether you've been hit or not. You're wearing a vest that has little laser sensors, right? And so you then load your gun with blanks, and you shoot the other people. It's not the mic. I've tried it with different mics. It's a software issue. I'm going to fix it. I have to keep restarting it. It's Miles. Yes, Miles. So the Miles gear is amazingly cool because it can tell all sorts of really fun stuff. Like if I have a rifle and I shoot the rifle at a tank, the tank knows that I'm shooting it with a rifle and is like, you're not out, right? The tank system goes like, yeah, that's a rifle. That's not, that's not going to do shit to you. You're still in, right? So that's but I got to play a little game. It was fun. The game was that there's a guy out there with a Miles system, and I've got a Miles system on, and we're in a forest, and it's who shoots the other one first. It was really cool. I did not win, but it was still fun. I really would love to play with Miles stuff even more. And yeah. So yeah. Yeah, but the point of all of this is that sometimes you might actually have live rounds that show up on a film set by accident. The other thing that has happened to numerous filmmakers is, let's say you want to film Batman's origin story, right? Any comic book fans here? Batman's parents getting gunned down in the alleyway. Who the hell cuts through crime alley anyway? But anyway, they're in the alleyway and they get gunned down by, this horrible criminal. Okay. The problem with that is that you're filming this in an alleyway, right? And if you're filming this in an alleyway, sometimes criminals, like actual criminals, might have been in that alleyway. And so I've heard film armors talk about finding live rounds on set because somebody else left them there. One armorer mentioned that they found a magazine with live rounds in it. They called the cops because they found this magazine with live rounds, and they're like, what the hell? And the cops came and searched and found the gun with a live round in the chamber of the gun that somebody had left on a street somewhere, just because. So yeah, you have to be super careful. You can't, and if you were filming and you find a Glock mag full of rounds, you can't just be like, oh, I assume these are good. You check shit, right? This is the problem he has, is that his client was responsible for all of that checking. And if his client didn't, that's literally her job. That is what her job is to make sure that none of the guns kill anybody on set, right? So all of these problems really, yeah.
The facts are different. The reason why the facts are different are that Miss Morrissey, in effect, suppressed them, in our case, by telling Mr. Teskey she would retrieve these. She told him in his pretrial interview, and that's detailed in our motion, that she would retrieve these and the state was going to collect them. Now, that never happened. But by telling Mr. Teskey that, Mr. Teskey didn't want to do anything with those rounds. He didn't want to touch them, and he wanted to keep them secure and safe. Now, I was not able to see those rounds until the second to last day of trial. Was the first time I saw him. Mr. Teskey didn't want to bring them. He didn't want to be accused of tampering or obstruction, and I didn't want to, and Ms. Morrissey said I didn't want the evidence. She, again, shaded.
Here's the problem he's got here. The problem he's got is that typically the police don't have an obligation to collect evidence. They can, but they don't necessarily have an obligation to. So what does that mean? Well, if I say, hey, if I message the Crown prosecutor, right, and I say, I think there's, I need pictures of the, I need pictures of this, right? Like of the crime scene. They can say no, we're not doing that, right? They don't necessarily have to collect the evidence. It's an issue. Mark, send me a message. We can try to figure it out, and I can try to sell you one in person. So, yeah. what he's saying here is basically that like the prosecution didn't collect this evidence when he asked them to. And it's like, well, you don't actually get to control the evidence. You should have just hired a private investigator to go collect them. That's available. Like, you could have done that.
It's the truth. The fact of the matter is, I didn't want to be in the chain of custody, nor did I want there to be any allegation that I had anything to do with something nefarious with regard to those rounds. So I told.
And this is smart. He doesn't want to be in the chain of custody, because if he's in the chain of custody, he's now a witness, right? You've got to have continuity of an exhibit. And what I mean by that is, like, let's say these things end up being evidence at a trial, right? And if you're wondering what these things are, they are burner rounds. They're for a particular type of thing. So let's say these are found at a crime scene by Cop 1. Cop 1 takes them, puts them in an evidence bag. He then hands them off to Cop 2. Cop 2 then takes them, checks them into evidence. Cop 3 takes that, bag of evidence, sends it off for analysis. Analyst looks over the thing and then sends it back. Cop 4 takes the thing, puts it back into evidence, and there you go, right? The thing is that all of those things are, you need to have the ability to call those people as witnesses, because I, as defense counsel, might say, how do we know that these things that showed up at trial or these things that made it to the expert are actually the same ones that are found on scene? How do we know? And so they have to be able to say, here is the continuous chain of evidence that that is there. The problem is that if one of those steps is defense counsel, this guy, then either he's got to testify or it's a break in that chain of continuity. So that's why he's saying he doesn't want to be involved. That's why you hire a PI for this shit, right? Because then he's a witness that you can call, and he can talk about that.
I directed Troy Teskey to turn those in to the sheriff, which he did, because we wanted law enforcement to have them, because I thought naively the state would do the right thing and would test them. Never in a million years did I think the state was going to hide those in a separate file under a separate case number, which then came out on the Baldwin trial. So that's what Mr. Teskey did. He turned those into the state.
But he turned them in after your trial. He turned them in after the trial was done. So that doesn't help you.
Aftermath of that, we weren't told what happened. We weren't told there was a separate file. We weren't told any of that. Because Ms. Morrissey basically held those in place with Mr. Teskey, it's the same thing as the court found in the Baldwin case. We weren't able to test those. We weren't able to utilize those rounds. We weren't able to even touch them because the state was going to seize them. Now, had we been able to use them, it goes back to the court's paragraph 30 on outlining the trail of how the live rounds got on set and how they got in the hands of Mr. Kinney and got to Rust. The state's theory at trial against Ms. Gutierrez-Reed was based on a series of pictures that they put together that Ms. Gutierrez-Reed must have introduced the live rounds because here's the pictures. Well, in reality, now that we learn that Mr. Kinney could have introduced those on October 12th through Sarah Zachary, and the jury could have been shown and seen those rounds. I asked the state repeatedly to test them, and they would not, even though they tested every other piece of evidence in this case, except the live rounds. They didn't test those for DNA and fingerprints, but they didn't test the Teskey rounds. They refused to.
And we already know why they don't test for DNA and fingerprints on those on rounds. So what if your client hands you physical evidence? I don't take it. No, we're not doing that.
Your Honor, second, as to the Hague report, I think this is very critical. The Hague report and the one we're talking about.
The Hague report is where I'm going hard if I'm him, because the Hague report is something that happened before his trial, right? And the Hague report could actually be relevant. The problem is that the Hague report is not super helpful to him, I think.
This is one that we never got during trial. Mr. Hague, the state's chief expert as to
she knows who Mr. Hague is.
the firearms, made a report that says it seems unlikely, although it cannot be excluded, that these tool marks on the firearm are the result of the damage incurred during the FBI's impact testing. He goes on to say that they do not appear to be original manufacturing marks or use and abuse tool marks. Now, then he follows with these tool marks are unlikely to have had any bearing on the operation of the revolver at the time of the incident based on the FBI's trigger pull data. However, the fact that he made the comments that they seem.
Whose fault would it be if this gun is a problem? All right, that's also Hannah's issue. This to me just helps convict Hannah. Like, let's say this gun had been modified to go off, super easy. Then that just tells me that Hannah's an even worse armorer than otherwise, because she allowed a dangerous gun on set. This might help acquit Baldwin, right? It might help acquit Baldwin if the gun can go off without a touch or something like that, but it convicts Hannah. That's why they're in very different spots here, is that this evidence convicts your client and acquits Baldwin. So, yeah.
Unlikely to have occurred during the FBI's impact testing and not consistent with original markings. We could have used that at the trial. And in fact, Your Honor, what's even more important is I asked Mr. Haig on the stand a very open-ended question. My question was, did you...
By the way, this is not the dunk that he thinks it is, because the standard thing is like, you shouldn't be asking open-ended questions on cross-examination. And he's like, I asked a very open-ended question on my cross. It's like, yeah, we noticed that you were asking all the open-ended questions on your cross. And did you maybe want to cross-examine instead of whatever the heck?
See any other evidence of modification or damage to that firearm other than what the FBI's testing did? He said, no, sir. Now, Ms. Morrissey tries to again spin that by saying that was in the context of the functionality of the firearm. I did not include the word functionality in that question. It was a very open-ended question. Mr. Haig said, no, sir. When in reality, both Ms. Morrissey and Mr. Haig knew at that time he had authored a report that showing that there was other damage to the trigger and to the sear. Now, later on, Ms. Morrissey points out in a response, after Hannah's trial, Mr. Haig is able to learn more about the firearm, and then he's able to change his conclusion. But at the time of the trial, Mr. Haig had a report saying there were unexplained tool marks and on the trigger and sear, and they weren't explained by the FBI's testing or the original manufacturer. Your Honor, we would have used that in the questioning and potentially raised an issue in the jury's mind regarding that jury instruction 14251, which is critical in this case. The jury sent out a question on that jury instruction. And that is, was this an uninterrupted chain of events? Or did something occur that interrupted the chain of events that would have been a proximate cause issue?
The problem is whose fault is it? Right? This is still her fault. So if he'd gone in and been like, oh, well, couldn't this have been modified to go off super easy? It's like, that's still his client's fault.
If there was damage to the trigger sear and we're able to cross-examine Mr. Haig on that, the jury doesn't have to believe his conclusion that this didn't affect the functionality. They don't have to believe that. And again, this goes back to Ms. Morrissey, who stated to this court repeatedly, certain items of evidence are not relevant. And it's her determination. She did things because they're not relevant. But that's not her call. That's not her call under the standard, under Brady and under exculpatory evidence, because the defense may have a different use for them.
The thing is that it is relevant, though. It is relevant to the issue of whether or not it is, whether this is something that actually would have changed the verdict, right?
I guarantee I would have altered my strategy at trial, as the court said in the Allison case. And that case is where the court reversed the conviction of a defendant's arrest record that wasn't disclosed to him. Obviously, he knew about that arrest record. It could have altered strategy of the defense at trial had we known about it. They were going to.
The thing is they say obviously they could have known about the problem with the arrest record case is that the arrest record case is the issue of. The arrest record case is an issue of the defense wasn't put on notice that they were going to tender the arrest record, right? That they weren't going to tender that information. And the problem that he has is that the prosecution here wasn't intending to tender it. So, yeah.
They were going to use it. Well, the same thing is here. If I had known about the report, we would have highlighted that and we would have made a strong argument under 14251. You can't be sure as jurors that this didn't affect it because we have a report here showing from Mr. Haig there was damage that he can't explain. And he was a very important witness in this case. It's inexplicable that we didn't have this report. And Ms. Morrissey only, this trial ended March 6th. It was August 31st that Ms. Morrissey first indicated in an email that this report would be turned over, and it was her failure why it didn't get turned over. There wasn't a very good explanation. There is no good explanation for not turning that report over that we could have made use of. The other thing that's critical to understand is this was coming out during the Baldwin interviews, which was going on simultaneously as we were having our trial. So it's just inexplicable that Ms. Morrissey would have hidden this evidence for use in our trial. And Your Honor, finally, the Seth Kenney interview, that interview had several things. And
the Seth Kenney thing is a little bit better for him, I think.
The interview was suppressed. I would have crossed him on several of the statements. Now, Ms. Morrissey's comment is that we knew about these other items through other witnesses. That's kind of the general statement she's made in response. The fact of the matter, however, is that Ms. Morrissey vouched for Mr. Kenney improperly in closing argument, saying he was, in essence, anybody that disagreed with what he said was lying, and basically that Mr. Kenney was telling the truth. So it would have been very effective for us to be able at trial to have used Mr. Kenney's own words in this interview that we did not get to cross him on statements he had made. So that is the import of that as to impeachment. These items are material. They are favorable. And Your Honor, I think the most significant thing that came out of the Baldwin hearing, and this court appropriately and was warranted, dismissed that case with prejudice because of the egregious and continuing pattern of discovery misconduct. And it didn't just start after Hannah Gutierrez-Reed's case. That's not, they didn't.
Here's the thing. The remedies for discovery violations are partially to punish for not doing it. It's partially for that. But it's not just a punishment. It's also to make sure that you get a fair trial. And so he can point and say that, like, that Morrissey sucks. And I mean, I'm there with you, right? She's done some shitty stuff, but that doesn't necessarily get him to the new trial. He needs to also be saying that this is an injustice to Hannah, that she would have or could have been acquitted if they'd had this. And I think he's doing a weaker job selling that. He is doing better at making his arguments, though, than he had been. This is the best I've seen him.
Conduct themselves ethically and then all of a sudden unethically in that case. This pattern of discovery abuse occurred in Ms. Gutierrez-Reed's case in the same manner as it did in Mr. Baldwin's case. And because of that, we are asking the court to consider dismissal in this court's inherent power, and the court lays out in its order the court's inherent power to issue a whole host of sanctions, or in the alternative, a new trial, Your Honor, because it's the significance of the items that were suppressed, favorable and material to Ms. Gutierrez-Reed that could have been used. We also have a situation, Your Honor, where I'm going to ask the court to order in this court's inherent power, if this court orders a new trial, to remove Ms. Morrissey as special prosecutor.
Okay. That's an ask. And the thing is it's not a crazy ask. It's not a ridiculous ask. But he's saying, okay, we want a new trial. And not only do we want a new trial, but you got to do us a solid and you got to kick this Morrissey person out of our trial. She can't be there for our trial. You got to make them get a new person. And there's two reasons why he might do that. One, legitimately, he may think that a new person is going to do better for his client and that a new person won't do the things that Morrissey did, right? That is legitimate, and I won't fault him for sorry about that. I just hit a button that I didn't mean to push. I was not actually swearing. But the other thing, the other reason why they want to kick Morrissey off is tactical. Why I would want to kick Morrissey off this file is that now that creates a huge, huge expense for the state. If the state wants to run this again, they've got to bring a new prosecutor up to speed on everything, and that's going to be so many more hours, right? So, and then the state may say, you know what? Fuck it. We're not doing this again. We're not doing this one again because it's so much money. So much money. So, yeah, it makes sense.
She has testified before this court, and I submit, and I don't do it lightly, her testimony was false in several material aspects. This court's findings in its order indicate that at the very least, she didn't exercise reasonable diligence to ascertain the nature of those Teskey rounds because she was at that March 6th meeting. But I would say at the worst, because Ms. Morrissey's been thorough in other aspects of this case, she did see those rounds. She did know that they were, there was 3 silver primer rounds before July 12th.
Okay, now you're saying that you did see them? That's a bit of an assertion here. So,
And so, Your Honor, I'm asking that this court, in its inherent power, remove her from further prosecution of the Rust case. And we are asking for a dismissal on the same basis as this court dismissed Mr. Baldwin's case.
All right, thank you. Response?
Initially, I want to just,
okay, now I just want to say we're going to take this up to 1.5 speed at the multiple requests that I've seen in the chat because Carrie Morrissey she's a little hard to listen to. She's a little hard to listen to here. But Morrissey is coming in with some attitude. She is coming in with some she's coming in with some opinions. And you see her facial expression, she's already got the who stepped in shit expression. Right? That's kind of what that expression is here. Like, hey, you're tracking your argument in all over my carpet. She really needs somebody to tell her that she needs to the thing your face is doing, it needs to not do it. Like, you need to stop your face entirely. The no face, Carrie. No face, no attitude. You need to not be dropping the stink on this one. And she just is really coming in. And somebody needs to tell her, to moderate this. And the thing is that Erlinda Johnson's gone. She's not going to be able to do it. So, yeah.
Mr. Bowles indicated that there was an affidavit provided by Ms. Johnson. I don't have that. I haven't seen it attached to any of the pleadings, so I'm not sure what he's referring to. So if obviously he mentioned it, can I get?
And this is the point when I was watching this earlier, I went, oh, damn. Damn. And this is a big problem because Bowles fucked up. And Bowles fucked up in ways that if I had a junior lawyer, like a first-year lawyer who was working under me, if I hired a student and they fucked this up, we'd be having a talk. I'd be like, hey, come on. We're going for drinks and we're going for lunch and we're going to, we're going to talk about this. And I'd be giving listen, I'm not mad, but I am disappointed. And this can't happen again. Because the mistake that Bowles made here is really, really fucking stupid. It is really, really, really dumb. And it's gonna cost him because he fucked this up real bad. Real bad. So what she's saying is, you're relying on Erlinda Johnson's affidavit. Where is it? Did you file that? And he's going, well, I think I do. I think I've got it. And it turns out he doesn't have it in his filings. And he then says, this affidavit's totally filed on the Baldwin matter. And you know what doesn't fucking matter? Anything that was filed on literally any other case on the planet doesn't matter for today. Sorry, you missed your chance. Somebody was saying I was crackling, so this is the kind of thing you just can't fuck things up like this, right? You gotta file the things with the things, right? You gotta file all the things. This is really, really, really bad. And let's see, do I have a good sound for this? There's a good sound. Now people are saying, can he amend? Can he amend and fix this? And the answer is no. The reason why he can't amend and fix this is that they had their hearing. He doesn't get to put in more evidence now. He had the hearing. So hearing is over. Hearing is done. He doesn't get to add more evidence later. You missed your chance, right? So, yep.
Get some insight into when that was provided?
Okay, I just love this because we're just gonna watch this part at 1 speed because it takes takes a bit of time to respond, and you just see her face here.
So if obviously he mentioned it, can I get some insight into when that was provided?
And she's like, come on, Nat.
Your Honor, I will try to locate this in the pleadings, but there was an affidavit filed with that's in the court record in the recent Baldwin response. But I think I've attached one in this case as well. I just would have to find it.
Oh my God, sir. No. He's like, I'm going to try to locate that in the pleadings. Okay. But, he's also like, I need to, it was filed on Baldwin. No, you don't get to use that. You don't get to use Baldwin's filings without filing them yourself. Yeah.
Well, is it in here? When did you file
I
it?
don't know how to fix it.
Judge,
So-
I thought I filed it with our motion, our reply to dismiss, but I'm not seeing it right away. The motions I printed out don't have the exhibit, Your Honor, so I'm not seeing it.
Well, I just went through every motion that's on Odyssey that has the exhibits attached, and it's not there. So
All right. If you can't produce it, I'm going to strike that part of the argument.
I think I have it. Come on. So I shut off my VPN. I'm hoping that it's going to fix things or help a little bit. This is a little bit like saying, listen, have you guys ever failed to do your homework when you were in university or high school or whatever? And you're just like, I don't know why you don't have the homework, teacher. It should be in there. I swear it's in there. I swear it's in there. Yeah. I hope now it's better. This is where Bowles is right now. He's like, yeah. I see people saying it's crackling worse. Give me a second. I'm going to try some further fiddling here. Give me a second. I'm just going to try to see if I can. All right. So this cable goes up and around and okay. I'm going to lose audio for a second. 1 second. People are saying it's good. Okay, I don't know why it's good. We're just going to run with it then.
Regarding Ms. Johnson.
Yes, Your Honor, and I would just say that part of the court record in the Baldwin case is that there is one filed in the recent response. Mr. Nick.
Part of the court record in the Baldwin case means absolutely nothing. Absolutely nothing. Where it like, sorry, no, it just doesn't matter. And so what ends up happening is that the court strikes his argument. She basically is like, for the purpose of this application, the Erlinda Johnson affidavit doesn't exist. Erlinda Johnson doesn't exist for the purpose of this affidavit, right? Or for this application. And do you think that affidavit was actually super helpful to, to the defense? Yeah. Becky says, how do you fix this when you don't attach the affidavits? Or when you don't attach the exhibits? You fix it by replacing the source of the problem. And the source of the problem is located between these glasses and this painting. If you just get rid of everything between the glasses and the painting, then this case gets way better, right? That's where the problem is. It's a very shiny problem, but yeah.
It's filed.
But it's not in this case.
Yes, I can't find it readily, Your Honor.
Okay, so I'll strike that part. Go ahead, Ms. Morrissey.
I will say, though, that this is an issue that Mr. Bowles raised in his initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation. I disagreed with that. I don't think self-preservation is a reason that you dismiss a case.
Carrie. First of all, she dismissed the argument about Ms. Johnson. So you know what you do? You just don't talk about Ms. Johnson at all. That was the right move. But also, you didn't have to do anything, but you also didn't need to, like, dig yourself a hole. Like, you didn't have to pick up this shovel that you're using to dig yourself a hole. And at this point, I think she's just hoping that if she digs far enough, she's going to, like, hit pirate treasure or oil or dinosaur bones or something. But she's digging herself a hole, and, like, she is above, she's, like, above a dump. So all there is down there is, like, sewage, and yeah.
there's a legal analysis that has to be done in order for the court to consider disqualifying a prosecutor. Mr. Bowles hasn't cited any of those cases, and he hasn't put that legal analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here.
Okay, Carrie, that is, you know what? I hope the judge quotes you on that when she gets back to the Baldwin the Baldwin motion, because you cited like no cases and yeah. Okay.
So having said that,
And you shouldn't have.
I responded to Mr. Bowles' concerns about the veracity of my testimony. Quite frankly, I'm not sure that it's relevant to his motion for a new trial.
I agree that
but
it's not.
because it's something that he's put in his motion and it's something that he has argued, there was no meeting about these TASCII rounds. I did not attend a meeting. I did not see the rounds until July 12th. I did not see the doc report until I believe it was July 12th or July 11th. I'd have to check my email. Whenever I got it and I provided it to the defense attorneys, I had no idea that there were 3 rounds that had the same characteristics as the live rounds from the set of rest until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that ended up happening is...
The problem that she runs is that there's a very real possibility at the end of all of this that the judge's ruling says Carrie Morrissey's testimony is not believable, or I found that she lied, or something like that. Carrie, just save your law license, right? Save your law license. And here's the other thing. Lawyers are riddled with imposter syndrome. It is basically the thing, when you are done with law school, it's like, congratulations, you are a lawyer now. Here is your imposter syndrome. And it's like, oh, this is a really big container. And it's like, yeah, you get lots of it. Lawyers are terrified all the time about how we're screwing up, or how we're we're just always worried about, like, am I doing this right? Am I going to get a complaint? Am I going to do I secretly suck at everything? Right? Like, and the thing is, this Elfligan's here with a good one. Lawyers are made up of 90% imposter syndrome and substance abuse. I have mentioned this before, and I'm going to mention it again because, of course, I am. I went to the Supreme Court, and I won at the Supreme Court. And you know what my thought after winning at the Supreme Court was, or one of my thoughts after winning at the Supreme Court was? I was like, oh, fuck. Because they put the videos online at the Supreme Court. Like, they post the videos. And so everybody, all the legal community could go and see that video, right? They could go watch. And a lot of them did. I've watched other friends as well, right? And the thing I was the thought that was in my head as afterwards, and when they said, oh yeah, the video is going to be up right away, is I was like, is everyone in the legal community going to think I'm an idiot? Right? Am I going to get back and everyone's like, oh, this is that guy who made those dumb arguments, right? And I'm just like, one lawyer who I know did me a tremendous solid. She sent me a message and she said, hey, I saw the result. You kicked ass. And she sent me some money and said, go buy champagne. And I was like, oh, cool. But But I was terrified that everyone was going to think I was an idiot after watching it. I was sitting there thinking, did I really say 10 beer situation to the fucking Supreme Court? Everyone's going to think I'm a moron. And lawyers, I'm not unique in that, right? I'm not like some guy who's extra special anxious or, well, okay, I'm lying there. I am a guy who's extra anxious. But even the lawyers who aren't extra anxious, they worry about these things, right? They worry about all of these, about all of these issues, right? So, and then here is Morrissey. I would be, if I was in the situation she was in, I would be trembling. There would be a waver in my voice because I would be terrified of all of this, right? The court is determining all sorts of issues about like whether or not you lied to the court, which might have serious implications about whether you get to go into court in future. I am, every time I walk into court, I am at least a little bit nervous. And when I say I'm at least a little bit nervous, that is including on cases where I know that it is literally impossible for the prosecution to win, right? Literally impossible for the prosecution to win. I'm still nervous because I'm like, oh my God, what if I fuck it up and they still win, right? I am, if I know that I've got a tough cross, I'm terrified. I'm worried. I'm anxious. I'm nervous. And you get in there and you do it anyway, right? That's the job. But I don't think she's nervous. I'm just like, Morrissey, you should be swinging less dick in this particular room. Pardon the turn of phrase, but holy shit. Wow.
It's actually quite clear because what happened in this case is that Mr. Teskey took a photograph of the rounds that he had in his possession and he sent it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to Mr. Bowles' motion for rounds that had the same characteristics as the live rounds from the set of rest until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that ended up happening is actually quite clear because what happened in this case is that Mr. Teskey took a photograph of the rounds that he had in his possession and he sent it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to Mr. Bowles' motion for a new trial. It does not show any ammunition that looks remotely similar to the live rounds that were found on the set of rest. He went further than that. Mr. Teskey said, I looked at these rounds, I couldn't find any with silver primers. Okay, so at this point in time, the state, this is long before I ever came on the case.
She's got balls and Bowles should make an application to get them back. I'm just like, are you really dropping sarcasm here? Are you really snarking this? Okay.
But the state understands at that point that the ammunition that he is in possession of does not look remotely similar to the live rounds on the set of rest. That doesn't make them material. It's okay for us to say we're not going to collect those because he sent pictures and they're not material. Then we go ahead and we do his pretrial interview. And I decide maybe I should go ahead and collect those. So I make that statement to him during the pretrial interview. Mr. Bowles can argue all he wants that he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over email and it is attached to my response. So Mr. Bowles understood we were not going to collect it. And it was during that email exchange that Mr. Bowles then provided more photos of the Teskey ammunition. And those photos matched exactly the photos that were provided to Mr. Kinney by Mr. Teskey. And they showed rounds that were completely dissimilar to the live rounds on the set of rest.
So, okay, great. Now I'll address this. If she was a guy, would we be pointing this out? Yes. Because I have pointed out that Bowles was way too fucking confident at points when his argument was stupid. So yes, I get that we need to be careful about, sexism and so forth, but and I pointed out when Spiro was being like too much of a confident, yeah. So the problem that they have here is that Morrissey doesn't get to decide what is material and what isn't. But just because Morrissey, the issue here is that they said we're not collecting them. That's not really a Brady violation and not collected. And the defense, if they were using due diligence, the defense could have gone in at any time and collected that, could have collected that, those, the ammunition, right? They had that option. And so when the defense is like, we decided not to do it, and she's like, I even offered a continuance. I said, we can give you time to go do it. And they're like, nah, bro, we don't care. So, okay. Yep.
This is information that is coming from Mr. Teskey, and it's filtering through Mr. Bowles. So Mr. Bowles doesn't get to come to the court now and say, hey, they should have collected these. The information that he gave us caused us to reasonably believe that they were completely immaterial. We had no idea that any of those rounds matched the live rounds from the set of Rust. Mr. Bowles provided us a photograph in January, a month before the trial, for heaven's sakes, that showed that they were completely dissimilar. So then let's jump to the trial. This is where Mr. Bowles' argument completely fails. He wants to rely on the court's dismissal of the Baldwin case, but he can't rely on that because what happened was these rounds were in the possession of his witness. He told his witness to bring them to court. He got to look at them. He told his witness, I'm not going to call you as a witness, and I'm not going to take these rounds. We're not going to touch any of this. I understand why he did it. Because, again, as I have said, sure, in a world of infinite possibilities, can you argue that these rounds somehow came on through Seth Kinney? I guess, but you can certainly you have a much stronger argument that this is how they came on through Ms. Gutierrez. Her father had these rounds that were exactly like the rounds that she brought on. So Mr. Bowles knew about this during trial. So when we're doing the legal analysis for whether or not Ms. Gutierrez gets a new trial, she does not get a new trial based on this ammunition that was in the possession of her father's good friend, and that she and her...
I love that line. I love the line there where she says it was in the possession of her father's good friend. That's a good line. And the thing is, let's talk about this one. What if you wanted to tamper with a trial? What if you wanted to tamper with a trial? Well, making additional ammunition that fits the criteria would be an excellent way to do it. And they don't have any information as to what these Teskey rounds are. Because it could be that these Teskey rounds are actually just something they manufactured the week before trial, right? Who knows what these are? I don't know what they are. But regardless, I don't think they're gonna matter here. And I think that any defense strategy around this, like the defense strategy, if they wanted to use them, should have been to collect them. But also, like, just do the things, right? So, yeah.
Lawyer had during trial, the state did not have. She and her lawyer had them during trial and chose not to use them. That is exactly what happened. So the legal analysis, the 6 factors that this court has to look at when deciding to grant a new trial, the second one is that the newly discovered evidence has to be discovered after trial. That's not the case here. This evidence was discovered by...
It wasn't discovered after trial. In fact, she's saying you guys had it when we didn't have it during the trial. And you chose not to use it. You chose not to explore that. And therefore, sucks to be you. Sucks to suck is basically her argument here. Sucks to suck. Okay, I don't hate it.
By Mr. Bowles during her trial when the state had no idea what those rounds were comprised of. He made the judgment call, hopefully after consulting with his client, not to call Mr. Teskey and not to use the rounds.
Okay, that was some shade. That was some shade. Hopefully after consulting with his client. You know what she just suggested there? Just quietly suggested? She just quietly suggested that like Mr. Bowles might have done an unethical. That he might have done an unethical. And I don't know that I would do that here, Carrie. I don't know that this is the time or the place or the what the fuck are you thinking? Like that is not the time here, Carrie. Okay.
Don't get to now come and say, we made a strategic error, so give us a new trial. That's not how this works. So the issue of the Teskey rounds with regard to Ms. Gutierrez's motion for a new trial, it is absolutely, it's not permitted under the law. It was not discovered after trial. Here's the other thing that the court needs to take into consideration. A motion for a new trial can be filed for almost any reason within 10 days of the conviction. Mr. Bowles is limited to a motion for a new trial based on newly discovered evidence beyond the 10 days. So Mr. Bowles, having seen those rounds for himself on the second to last day of trial, having infinitely more information about those rounds than I had, easily could have filed a motion for a new trial within the 10 days, but he chose not to do that. So he has given up, he has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court, Mr. Bowles filed a lengthy motion for a new trial, and never once did he articulate or argue the legal standard that is required for a new trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard.
She has gone full fucking knives out. Full fucking knives out. Did you hear what she just said? Did you hear what she just dropped? I'm glad Ms. Gutierrez is listening to this. She's like, I want your client to know how much you suck. Fuck. Carrie, listen, at times in this trial, I have been impressed as fuck with your work. At times, I have thought that you are an absolute, like, wood chipper on legs, just running around eating lesser counsel. But that was a choice, right? That was a whole decision right here. And I feel like you need somebody to like pull the reins in here. You need somebody to say, ooh, because I did not love that. I did not love that choice. And there might be a time and a place. And you know what? The time and the place might have been during trial when, like, Bowles, when they were running her, her or her interview or anything like that. But, wow. She's like, tell your client, I want her to know that you suck. And I'm like, you don't get to say that because you suck too. You're wearing all the suck in this. Yeah. Oh my God. She needs to remember that she and Bowles never had kids together. She needs a brake pedal. Like, her car is just gas. That's it. It's all gas. She's like, I know how to go fast. I don't know how to go slow. Gotta go fast. Gotta just like full speed ahead. And it's like, Carrie, you've got to avoid the rocks. And she's like, gas pedal. All I got is gas pedal. Yeah, but she's also asking for this to be thrown out on the basis of like untimely filing. Carrie, did you not see your thing on the Baldwin thing? Holy shit. Yeah.
That he is required to meet was never mentioned one time during his motion. The state mentioned it in the state's response because these are the 6 factors that the defendant has to meet in order to get a new trial. So let's move on to the Kinney interview. Mr. Bowles outlined, I think, approximately 20 statements in that interview that he had specific concerns about. And he's absolutely right. I want you to know this was suppressed. The moment that I found out that this audio recording existed at the district attorney's office, I immediately provided this to Mr. Bowles. I couldn't believe that there was an audio recorded interview of this witness that had been sitting at the district attorney's office that had never been uploaded to the discovery server. The previous prosecutors were unaware of it. I was unaware of it. My team was unaware of it. It was absolutely a failure. There's no question about it. I immediately provided it to Mr. Bowles.
Okay. Where the fuck is this going? Like, she's like, yeah, that tire fire is totally a tire fire. And I'm pretty sure there's like some dumpsters, some diapers in there and like, maybe some old nerve gas canisters. Like, okay, cool. Where are you going with this argument?
But that's not the end of the analysis. The analysis is Mr. Bowles has to meet those 6 factors in order to get a new trial. So what Mr. Bowles did was he filed a motion and he outlined 20 statements, the vast majority of which were statements previously made by Mr. Kinney that were already in the possession of Mr. Bowles and Ms. Gutierrez. So then when we get to Mr. Bowles' reply, what we see in the reply is that the 20 statements have now basically been narrowed down to 5 because someone had to come and point out that Mr. Kinney had already talked about the fact that there were 325 rounds that were taken to Texas. He had already made all of those statements about Sarah Zachary being the boss. He'd already made all of these things. So,
all right, let's talk about this. If I have 2 statements from a witness, right? Let's say my client robbed a bank, right? And the bank teller gives 2 statements. And those 2 statements that they give to the police are virtually identical. Well, I definitely want both of those statements because there is no way on any planet that humans live on that those 2 statements are 100% identical. And the reason why is because humans are not capable of giving 2 statements that are 100% consistent with each other. And in fact, if it ever happened, I would assume that something was super rehearsed because that is just not how humans work. We are just not able to do anything like that. And each of those little inconsistencies is a potential basis for a cross-examination. Now, a lot of people don't think that this is fair. They're like, well, why are you cross-examining this person on a thing that you know is like some trivial fuck up that they made because people have imperfect memories? It's like, well, because I'm a defense lawyer and because that is the job. And ultimately the jury gets to decide if it's a trivial fuck up or if it's serious, right? I get to argue that this might be serious inconsistencies. So even if he said the statement also in another statement, I'm like, absolutely, that's fantastic because I want to see what the differences in those 2 statements are. Absolutely, any statement from a witness is useful for impeachment on a cross. It's useful. So you're losing me here, Carrie. You're losing me. Maybe you got to take off the glasses and point aggressively with the arm of them.
Mr. Bowles filed this motion, having seemingly not reviewed any of the discovery that was in his possession with regard to Mr. Kinney's statements, so that he could file a motion that actually had the material issues related to the Kinney interview. So now we're down to the 5 issues that Mr. Bowles.
So she's just accused Bowles of not preparing for this. Yeah.
Bowles ends up relying on, because the other 15 turned out to be things that really were already in his possession, were already within his knowledge.
Okay, 5 is pretty good.
So when we go through and we look at these, I'm sorry, there's I think he narrowed it down to 8. So where he is right now is he's asking the court to grant a new trial because the interview with Mr. Kinney talked about that there was a standard that Ms. Zachary was the boss and she's managing things, which allows the armorer to focus on guns. This came out during trial. Not only did it come out during trial, it was fully articulated in the text messages between Mr. Kinney, Ms. Zachary, and Ms. Gutierrez.
Yeah, okay.
Hannah has more experience on Westerns than Mr. Kinney did until 1883. Well, I would hope so, because Mr. Kinney is not an armorer. So the comparison between Ms. Gutierrez's experience and Mr. Kinney's experience has absolutely nothing to do, is completely immaterial with regard to this case. And importantly, the factors that this court is required to consider do not create a situation where Mr. Bowles gets a new trial because there's something out there that could be potentially impeaching. The law actually doesn't give him that with regard to a new trial. His third issue, prop masters who handle guns won't call out armorers to test bullets. I don't understand. I mean, I don't understand how that could even be remotely material. We had plenty of evidence from people who were on the set, who work on movie sets. Mr. Kinney does not, by the way. He doesn't work on movie sets. And we had an expert come in and say that armorers are supposed to test the bullets. So how is this material? The sheriffs confuse the replica guns with the real guns. What does that have to do with the elements of the offenses that Ms. Gutierrez was charged with? It has absolutely nothing to do with those. Mr. Kinney heard nothing but good things about Hannah on set, and all of the concerns about safety that came out later he hadn't heard about. Judge, that's all in the text messages that Mr. Bowles had. He had all of that. Mr. Kinney actually, there's an exchange between Mr. Kinney and Ms. Gutierrez where she talks about the director saying what a good job she was doing, and Mr. Kinney.
So I just want to say, if I was the judge, this entire thing, and it's not just Bowles and it's not just Carey, it's both of them. Both of them have made choices about how they want to present this. And I just want to say, I would be sitting there this whole time looking at them like this. This would be my facial expression. The whole trial, I'd just be sitting there going, this is how I would feel if I was the judge here. And I would just be like, wow, I have to just decide which of this, like which one of you stacks of garbage has to win this one. Which one gets to be the finest stack of garbage? Yeah, okay. Okay.
He responds. All of that is in the text messages. This was always in Mr. Bowles' possession. Mr. Bowles didn't review it. He didn't use it during the trial. That was his decision. Sabotage could be anyone on set. Mr. Kinney doesn't work on movie sets, and he was never on the set of Rust. Okay, so this is his speculative opinion. It was also something that Mr. Bowles had the opportunity to fully explore at trial, and did in fact fully explore at trial. Because Ms. Gutierrez left the ammunition unattended, anyone could have messed with it. Yes, we went through all of that. Because these firearms were left unattended, yes, anyone could have messed with them. We knew all of that. All of that came out during trial. The idea that if the camera crew had gotten their hotels, would they have still felt unsafe? This is number 7 in Mr. Bowles' reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form. That the assistant director and Alec Baldwin didn't give Hannah every ounce of support, and she got pushed around. Well, this was Mr. Kinney's opinion, but you also have to keep in mind, Mr. Kinney was never on the set of Rust. Mr. Kinney never met Mr. Halls, the assistant director. He also never met Alec Baldwin. So this is a statement that he made that has absolutely no foundation, and also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of the third Hague report. And look, I understand that to a certain degree, the job of a defense attorney is to make things seem perhaps a little worse than they are because it helps their arguments. Nothing was intended.
That is straight truth. But oh Christ. Listening to her is like pissing out a strip of sandpaper. It is really okay.
Intentionally buried. This case had a terabyte of discovery. There was new discovery coming in constantly. This was a report that I believed I had forwarded on to our staff to have it uploaded to the server. When I realized during the Baldwin preparation for trial that did not occur, I immediately I took full responsibility for it. Mr. Bowles points to the email where I took full responsibility for it as though I've done something wrong by taking responsibility for it. I believe that it had been forwarded on. I went back, I looked, it had not been. We did the best that we could to resolve it at that point in time. And listen, the problem with Mr. Bowles' argument with regard to the Hague report is twofold. First of all, the Hague report clearly says the microscopic marks on the tip of the sear did not affect the functionality of the gun. Furthermore, Mr. Hague has since learned exactly how the destructive testing of the gun was being done and has now come to the opinion that these microscopic marks were made by the testing at the FBI. So Mr. Bowles wants to say, Judge, it doesn't matter. The fact that the guy has changed his opinion after he got new evidence, that stuff shouldn't matter. Well, it most certainly does matter, because when you look at the 6 factors that this court has to consider when granting a new trial is the probability that the result would be different if the new trial was granted. So if you have an expert who said, initially, I'm not exactly sure where these microscopic marks came from, but I don't think that they came from the FBI. Then he goes and he talks to the guy at the FBI, gets more information.
So the thing is I like the parts of her argument where she's making fun of Bowles, and I like the parts of Bowles' argument where she's making fun of her. And that's just because at this point, I'm like, you guys both suck. But I want to hear somebody better make each of those arguments. Here's what I want to see. Here's what I want to see at this point. They should tap these 2 lawyers out. Tap them out. And the judge should say this needs to be reheard and redone via 2 different lawyers. And I want to see them bring in Bullion and Erlinda Johnson, the 2 lawyers who are off the file, and have them argue it out. Like, oh my God. Oh man. Yeah. Okay.
About how that testing was done, and the expert then says, okay, now that I've got this new information, I've changed my opinion. I think that they did come from the FBI. Well, that goes directly to the first prong of the 6 prongs, which is whether or not a new trial would result in an acquittal if the court were to grant the motion. It's not going to, because Mr. Hague got more information about the testing, modified his opinion, and the other
guys, I'm gonna skip a bunch of her because she goes for 40 more minutes and we got to cover some other stuff. So we're going to skip ahead a bit because she goes on forever.
Says that the obligation of the state has to do with collecting evidence from the crime scene. And they make it very, very specific. And where indicates this is very limited. The state is not required to scour the planet Earth for potentially exculpatory evidence. It is evidence that is from the crime scene. This is not evidence that was from the crime scene. This is evidence that was in the possession of a defense witness. Mr. Bowles knew in January that we weren't going to collect it. He knew that it had never been collected. He certainly did know that because he was in contact with Mr. Teskey. Mr. Bowles could have had that ammunition tested. I mean, the chain of custody was shot. There was never going to be any chain of custody with this anyway. This isn't something that was located at a crime scene and was taken into evidence. This is something that was sitting in a defense witness's garage. So Mr. Bowles could have had this tested. He opted not to have it tested. He could have had it tested. He could have had those test results.
Here's the other thing he could have done is he could have made a Brady argument way back when, right? He could have said, I want to compel them to test it. But he didn't. And you don't get to sit on your thumb and then argue about it later, right? This is not something you get to sit and camp out about.
Paired with the test results of the FBI, And the best case scenario for the defendant is that would indicate that the same powder that was used in the ammunition that was in Teskey's possession is the same powder from the powder, or consistent rather, with the powder from the ammunition from the set of Rust. And that exact same powder is used in millions and millions of rounds of ammunition everywhere. One of my concerns since this issue arose has been the fact that Mr. Teskey 2 times sent photos of the ammunition in his possession, twice, and never sent a photograph of a round with a silver primer. In addition to that, he indicated, I have looked at these rounds and there are none with silver primers. And then 2.5 years later, he shows up with ammunition that looks just like the ammunition from the set of Rust. And again, you can buy this ammunition at any gun store. This isn't special. You can get it anywhere. You can get ammunition with these exact same characteristics at any gun store. So out of, to be thorough and complete, the where analysis doesn't match in this case. It absolutely is really irrelevant to this case, because the defense had more access to this ammunition than the state did prior to Ms. Gutierrez's trial. Now, with regard to the Baldwin case, that's a completely separate issue, because that is information that was in the state's possession prior to his trial. So there are real issues with regard to that disclosure. That's completely different. This case, Mr. Bowles had it in his hand. He had it in his hand during trial. And Mr. Teskey, I'm not making things up, Mr. Teskey told law enforcement on video, I offered this to Mr. Bowles and he said he didn't want it. That's what Teskey says on the video. So,
So I think Bowles fucked up in part by putting so much weight on the Teskey ammunition, because now it lets her respond like the Teskey issue is the only issue, right? If I'm Bowles, you know what I say? I say the Teskey thing is not my main issue. I say the Teskey thing is icing. That I want to argue the Hague report, and I want to argue the Hague and the Seth Kenney interviews. That's what I want to argue. And I just say, and it is further egregious that she never turned these things over. But that's not the most significant thing in this trial. Take the wind out of her sails, because she just gets to spend this entire time dunking on the irrelevance of this information, and basically she's dodging the point. Okay, let's go to Bowles or so.
That motion. That is a separate motion. There is case law on that motion. I would ask the court to deny this motion. Thank you.
Oh, let's skip back here a little bit. So she's got her last little bit here.
Mr. Bowles actually went so far in his reply to say that the Teskey evidence was deliberately hidden from him. The Teskey evidence wasn't deliberately hidden from Mr. Bowles. It was provided to him by his own witness. He could have had it tested at any point in time. I would respectfully ask the court to deny Mr. Bowles' motion. And if Mr. Bowles wants to file a motion to disqualify me, he can file that motion. That is a separate motion. There is case law on that motion. I would ask the court to deny this motion. Thank you.
Thank you, Ms. Morrissey. Reply, Mr. Bowles.
Yes, Your Honor. Thank you.
I just feel like Judge Summer she's lovely. I just am a big fan of her overall. I feel like she has aged 5 years from this. Oh my God. Yeah.
Honor, I want to start off by telling the court several initial points. The Teskey evidence that was deliberately withheld was the Teskey supplemental report. We still have Brady rights on appeal. That was not given to us, the March 6th report. So Ms. Morrissey misconstrued that. She also misconstrued the idea that I didn't want the evidence. What I told Mr. Teskey was that I didn't want to be in the chain of custody of those rounds. And I was actually a good idea that I did not, because Ms. Morrissey is now accusing Mr. Teskey, in essence, of planning silver primer rounds in that group of rounds.
So you hire a private investigator, and no shit, she's accusing him. If you had brought this evidence in, she would have cross-examined the ever-loving fuck out of Teskey. And the thing is that not only would she have cross-examined the ever-living fuck out of him, I think he would have it could have gone really badly for them. But Yeah. Okay.
She just made that argument. Now, Mr. Teskey originally, way back when this case started, did a cursory search through the rounds and did not locate any silver primer rounds. He thereafter didn't touch them, and that's where the text came from very early on. He didn't touch them. Miss Morrissey was saying she's going to come get them. That's what she said at the interview. So by the time we had the email exchange, which by the way, Your Honor, she didn't email me. I emailed Miss Morrissey trying to figure out where this was at. And then she responded, I'm not going to get these rounds. It was too late. This court had made clear, and I don't remember the exact date, but that we weren't going to continue the trial. There was not sufficient time at that point to test them. And
the court might, the thing is no matter what the court says, right? If the court says there is no universe in which I grant a continuance, you still have to fucking ask if it comes up. Because courts say this shit all the time. Lawyers know that courts talk about all sorts of shit and that they don't necessarily do what they say, right? When a court says there's no way I'll grant a continuance, you don't know if they'll grant a continuance once something else comes up. The court is just saying, like, I'm unlikely to, but if they say, hey, a new witness walked in today with new evidence, like, let's imagine Teskey isn't walking in with ammunition. Let's say Teskey is walking in with a video of a gremlin, like a literal, like, movie gremlin, you know, with the ears and the teeth and the nose and all of that, planting live ammo on the set, right? And it's like, okay, now we've got this literal film gremlin tampering with the ammunition. The judge absolutely would grant a continuance on the basis of, yeah, that new evidence just walked in the door, right? You So you just have to, like, can you hear me? Yes. Okay. Hopefully. Guys, I don't know. Did my computer do a thing? Can you hear me? Okay, good. Okay. So I had a trial where the judge told me he would not grant my objection. And it was the same objection that I kept making over and over and over again. I kept making the same objection, right? And the judge was getting pissed, and he's like, stop making this objection. And the thing is I objected every time, even though the judge said, stop it. And on appeal, that saved me, because if I had stopped objecting, then I would have waived that objection. I would have lost it.
And we could not test them, Your Honor, because the FBI had the powder for the live rounds on set. We don't have an ability to match those unless they're tested at the FBI. So the state did suppress those. And we're not asking on the where standard for them to go to the ends of the earth, as Ms. Morrissey said. They knew the individual who had them. They knew this early on. And that, as the court put in paragraph 30 of the...
Sir, you could have asked for a picture of the powder at any time. You could have asked for a sample of the powder if you wanted to do your own testing. Bullshit, right? You could have done this.
Court's opinion from July 31st, there was a progressive trail established of how these rounds could have gotten to the rest set through Mr. Kinney. Now, Ms. Morrissey wants to denigrate that idea, but finally today she said, well, I guess in a wild speculation, you could say Mr. Kinney brought him. No, that's a real possibility. That's something the jury should have been able to consider, but they never wanted to acknowledge any possible defense theory, which is why they suppressed everything, because Ms. Morrissey didn't think it was relevant. With regard to the Hague report, Ms. Morrissey made extensive argument about how we should have divined these microscopic or very small damage to the trigger and sear through looking through thousands of pictures and having our experts somehow divine the opinion of Mr. Hague, that this, or come to the same opinion as Mr. Hague. But what she's ignoring and trying to get this court to ignore is the failure to produce that report from the main state witness who was opining on whether the gun functioned correctly. And I just accepted that at trial because I accepted his answer that there was no modification that affected, and no modification other than the FBI testing, which that was the case in the pretrial interviews. That was the case at trial. Ms. Morrissey said pretrial interviews are where we can figure these things out. Well, we couldn't even figure out at trial because he didn't answer the question in a truthful manner. What he said was there is no other modification to that trigger or sear. Now that's false. And Ms. Morrissey wants to conveniently
Except
skip
was
over
his
that.
opinion
And the
at
idea
that
that we
point.
should have had this and it's no harm, no foul, even though we have abundant proof of false testimony, and she's admitted we didn't get the report. That's something we could have absolutely crossed on and used under 14-251 and this idea that the court pointed out in Mr. Baldwin's order on the negligence of third parties and the proximate cause argument. Your Honor, regarding the Seth Kenney statements, I did read it all. I boiled it down and replied to the 8 most important, and that's why I wanted to get to the court to consider. Ms. Morrissey tries to, again, run away from the idea that she suppressed something by characterizing as we had it all. Well, we didn't have it all, and we didn't have it specifically all from Seth Kenney's mouth. So that's not true, the arguments that were just made, and we could have crossed him on that, and he was an important state witness, as this court knows. Your Honor, with regard to the Teskey grounds, what Ms. Morrissey didn't address at all is not the new trial grounds, but we've asked for a dismissal under the court's inherent power. And the whole Teskey argument, and I've been open about it, I didn't see those till 2 days before the end of the trial. At that time, there was no way to do anything with them because they had been suppressed in essence by the state not getting them, Mr. Teskey not wanting to touch.
You knew where they were. You could have gone to see them anytime you wanted. You had visitation rights. You had custody rights. You could have gone and picked them up. You can't be like, well, I just sent a Christmas card once a year to those rounds with $5 tucked into that. And so there was really no way for me to, no, you got to go play daddy and pick up the rounds or have your person pick up the rounds. Bowles. Come on.
For the exact reason that Ms. Morrissey accused him today of planning rounds. That's the reason why he didn't do anything with them. But Your Honor, the Teskey evidence and the court's opinion in Baldwin goes to the remedy of dismissal because the egregious nature of this prosecutorial misconduct in this case, specifically by Ms. Morrissey, her false testimony, does a blow to the whole system of justice. It's not just to this case. As this court appropriately found and was warranted in Mr. Baldwin's trial, this affects the whole system. Why people respect the system, they voluntarily turn themselves into jail when a judge rules, is because they have respect and confidence and public trust. What Ms. Morrissey did in this case is she destroyed public trust across the board in the rest prosecutions on a case that was watched by the nation and the world. A case being paid by the taxpayers, one of the biggest debacles, ethical misconduct, probably in the history of New Mexico. But this court appropriately dismissed that case to.
I'm gonna just go ahead and say I'm sure New Mexico has had bigger ethical problems than this one. And that's not to say that this is nothing. That's not to say that this is like nothing. But it is to say that, oh, come on. Like, come on. We know there have been bigger issues than this. Come on. I would be rolling my eyes in here.
Restore and maintain and uphold the integrity of our system. And so I'm asking the court to consider doing that in this case as well, because it's not fair and it's not right when the prosecutor doesn't play by the rules and it doesn't engage in fair play. That undermines our entire system.
That's a good argument. Good for you, sir.
All right. Thank you for your presentations today on this particular motion. I will consider these arguments as well as the pleadings. I will issue an order. I plan to issue the order early next week. All right. But at least next week. All right. Let's move on to the motion for immediate release.
Okay. So I'm going to say Bowles is doing well for one thing. The thing where I say Bowles is doing well here is that not getting a decision right away is a win for Bowles today. Because if there was a decision right away, the decision right away would have been go to hell, go away. That's what we could have seen today. But we didn't see that. So Bowles is still in the game. But I think we're going to see a decision that basically just says, and the thing is she's going to issue a written decision, right? And I don't know what the written decision will be. The written decision could be, fuck these guys, but the trial stands. It could be, we're doing, but she does go and she has him argue for immediate release. So let's watch some of that.
Yes, Your Honor, and that really, I think, is predicated upon the court's ruling, whichever way the court would rule on the instant motion we just argued. So I'm open to suggestions of this court or counsel. Judge, I don't know if it's ripe until this court rules.
I think it's ripe. You've got section 3111(1)(c), and you've also got the case law.
She's like, argue it, you moron. Christ. He's like, I don't know that it's ripe yet. It's like, argue it like you've already won, dude. Argue the point. When the judge says argue, you go.
Yes, Your Honor. And with that, I am asking for immediate release, and some of the same arguments we've already presented with regard to the Hague third report. Judge, this is on appeal. It's been remanded on a limited basis for this court to rule on the motion for new trial. I know that the state has responded that there are issues that Ms. Gutierrez-Reed has had with regard to statements she's made. But Your Honor, the fact of the matter is, while she was on pretrial release in this case, she didn't have any violations. She didn't go anywhere. She's not intending to flee. She's not intending to try to avoid prosecution. Your Honor, and I would submit that if or to avoid her obligations to this court, I would submit that she's not a danger. If this court were to enact conditions, she doesn't have firearms. She could be on house arrest or whatever conditions this court deems appropriate. While this case is pending, whatever decision this court makes early next week, that she'd be allowed to be released pending the appeal. One of the problems, Your Honor, is that the length of time of this appeal, if this case proceeds to appeal, is likely to take longer than her sentence. And that's just a fact of how the system proceeds. And
this is like the reasonable argument, right? You got to say, like, because it sucks. Like, let's say you get given 2 years in jail, right? And then you appeal, and the appeal takes 2 years, and they say, congratulations, you won. And it's like, well, I already did 2 years in jail. So, why did I bother? Right? So this is the argument. I think it's not.
So we're asking with the issues we've raised for this court to consider releasing her, while this court considers this motion and the appeals court considers our arguments.
Ms. Morrissey.
Sir, you're arguing for the release of your client. You are arguing for the freedom of your client, that your client should be released from jail. And your argument there was like, Christ, a fart in an elevator lingers longer than that, than that argument. I would be coming at this a little, I would have been coming at that a little harder, right? And if that was my lawyer, who came in and just kind of half-assed that and was like, oh yeah, release her. She's going to be in there a long time. He sucks at arguing for release. Sucks at that. Yeah.
Your Honor, the state objects to the release of Ms. Gutierrez. Mr. Bowles indicated that she didn't have any violations of her conditions of release. I think we didn't have any evidence of those violations that we could bring to the court, but we did discover when listening to Ms. Gutierrez's jail calls that she was in possession of alcohol during the trial. Discussed violating the court's order that she not possess firearms during her jail calls. And she has already signed a guilty plea to a felony in her other case. So Mr. Bowles' argument that she doesn't have any other criminal history, I know that he argued that initially in his motion, and she has now since signed a guilty plea in that case. So I'm not trying to beat him up over that. When he made that assertion in his initial motion, it was accurate in terms of her convictions. It is no longer accurate. And based on those issues, we would ask the court to deny Mr. Bowles' request to release Ms. Gutierrez. And I will say that one of the things that has mystified me in terms of the way that Mr. Bowles is handling his appeal, he's filed more than one motion.
Oh, God, don't talk about how somebody else's procedural things mystify you. Oh, my God. Sometimes I'm just like, you are making some choices here, and I wish you would make better choices, because holy shit, don't dunk on him. when you are on the ropes.
Before Your Honor, asking that the court release Ms. Gutierrez. I think this is the third such motion that I have responded to. I think the court has only heard 2 of them because one of them was never set for a hearing. But if Mr. Bowles has concerns about the fact that his appeal is going to take so long that essentially Ms. Gutierrez will have served her entire sentence by the time his appeal is over, I don't understand why he isn't addressing that with the Court of Appeals. I think that he can do that. I think that he should do that, and he should have already done it. So
she's like, hurry it the F up. And also, you're in the wrong court, right? You're in the wrong court.
we would ask this court, based on everything that we've gone through this morning with regard to Ms. Gutierrez's motion for a new trial, the 6 factors that have to be met in order for that to be granted. I have never seen a case in the state of New Mexico where the district court dismissed a case post-conviction based on discovery issues, and I don't think that Mr. Bowles has pointed to such a case.
You might be the first. You might be the first. Yeah. Okay. You're out to maybe make history, is what she's saying.
So I don't know that asking the court to dismiss the case against Ms. Gutierrez based on the 2 issues that Mr. Bowles was unaware of during the trial is appropriate. The appropriate remedy is motion for new trial. He can't meet those 6 factors. So I remain confused as to if Mr. Bowles has concerns about the length of time of the appeal and how it relates to his client's sentence. File a motion asking for release before the Court of Appeals, because they have a better idea of how long their appeal is going to take than we do. But for some reason, he's not done that. So we would oppose Ms. Gutierrez's release. It sounds like the court's going to rule early next week. So certainly if the court rules that Ms. Gutierrez gets a new trial, the court can immediately release her. I'm not sure the court even needs to have a hearing on that. I think that's well within the court's power. But the state objects to it, for the record. Thank you.
Your Honor, just briefly. Yes, Your Honor. Thank you. Just briefly, Your Honor, the reason why we were asking for dismissal in this case is that it is the most egregious case I have ever seen of prosecutorial misconduct. And there's always an instance where you have to ask a court for something you're compelled to do on behalf of your client, because there's no case I've ever seen that is this bad. Mr. Baldwin.
Okay. Maybe you need to read more, sir.
Lawyers wrote that in their response that they recently filed, and this court appropriately dismissed that case. That's why we have asked for the dismissal remedy, because this case is so egregious. What happened? Lying, cheating, hiding evidence. Second, Your Honor, with regard to the release, we wanted to go through the chain of command. We wanted to address that with this court first, and then we will, depending on this court's ruling, we would go to the Court of Appeals next. But I wanted to respect the chain of command and respect this court's authority over the proceedings, and this court had previously ruled on those issues. So that's why we filed it. So, Your Honor, we would respectfully agree with Ms. Morrissey. If this court rules in our favor early next week, this court wouldn't have to have a hearing and could just release her.
All right, thank you, counsel. Again, I appreciate your presentations today, and I do appreciate your briefing. I'm going to consider your motions. I will address them in 2 separate orders. Your motion for release, immediate release under 5402, and then the order on discovery violations and inherent power, new trial and dismissal. All right, thank you.
Thank you, Your Honor.
She certainly did not intend to rule on that one today. But basically what they've come to is, listen, if we're gonna, if she's gonna get a new trial, then maybe she should be released pending that new trial. And if she's not, then sucks to be her. Sucks to be her. Okay. This is... I did not enjoy her shenaniganery. That I thought sucked. So yeah. I was just like, oh my God, why is this always such a thing here? I saw some people in the I was asking what I should order, and some people said what is it? Some people said pho. Sadly, the pho place at order is closed because it's 9:30. I also thought about dim sum, but they're closed too. Damn it. I'm at the hour where things start to close, and so my options for food get less and less as time goes on. All right. So, order something that flies, walks, and swims. Seagull? I don't think I can order seagull. All right. Do we want to cover Eric Adams? We're not going to cover Eric Adams in full, but we could cover some of Eric Adams. Holy shit, Mr. Beastburger is back on my delivery list. That's a thing. That's a whole thing. Interesting. I'm not ordering a Mr. Beastburger. Somebody says, do I happen to have ADHD? Or no, whoever. Do they? So, all right, get duck. I don't know where duck is. I don't know where I'd get duck. I don't think duck is an option. Liquor is an option, but that is not really a good dinner. All right, let us. All Happy is where I'd order Chinese food from. Maybe I should have a look. Okay, let's briefly look at Eric Adams. We're going to go through the overview. We're not going to go through it in full detail, because if we go through it in full detail, then I am going to we're going to die, because it's 57 pages. So we're going to go through the overview, get the bird's eye view of what this thing is about. And then once we've done that, we'll move on, because we got a lot of stuff to cover today. So many different things. And we're going to cover as many or all of them as we can, but we gotta move along, because I've only spent like 2.5 hours on this. Okay. So let's pull this up. People are saying Eric Adams press conference. Okay, I have to. Eric Adams press conference. Can I find that online? Yeah, we can. We can watch that. So, whoop-de-whoop. I'm going to bring that over. We'll watch that one. There we go. Oh, and I got to swoop, and I got to read super chats. That is so. Whoop. Rainman YSC, Woot started working out with free weights today for the first time since starting rehab. Limited to curls for now. That is still awesome progress, and I'm glad to hear it. Jackie Lindy, did you see my email about Ryan or Oren Roth, where the father's bad misdeed unmasked the son's unrelated but worse misdeeds? Son's crimes are really bad. I want to cover that one at some point, because, yeah. Becky, today is my 38th birthday. Happy birthday, Becky. That is awesome. Devin says the member-only discount only appears in the cart. Okay, that's important. Jolene, what is the picture of behind you? A rifle and spent cartridges or spent casings. Jaded Juror, thank you for the 5 gifted memberships. Much appreciated. Just because, will you talk about the House of Commons shenanigans yesterday as a refresh between stories? Maybe, except that makes me disappointed. Jaded Juror, thank you for the membership. Much appreciated. AKA the Cat Lady. At some point tonight, can we do a quick check on the Sarah Boone interrogation to double check the Miranda warning? So like 2 minutes. Maybe we can do that. I'll think. Auburn Legend, buy the hot sauce so we can get better sound gear. I don't know why I'm having so much trouble. Elizabeth, me today. What the flip? Yep. I almost called this WTF in law, and then I was like, I might get in trouble for that. Lorraine Chisholm, thank you for the new membership here. Trust but verify with 2 T's. Thank you for the 10 gifted memberships. That is Mimi2TG. Thank you for the YouTube membership there. Beach, please. Congrats on the hot sauce. Can't wait for the U.S. ship. Me either. Dylan Schultz on Emily Baker's show. I made a joke about you wanting the Coburger trial as far north as possible to be close to Canada. Did you read that comment? I missed that comment, but solid. Jaded Juror, Ian, the mic is only crackling when you move. I don't know what the mic is doing. It is, yeah. Nancy CC70, audio is fine here. Thank you. Late but present. I agree, Runkle. The best we've seen of him so far. He did really well at the start. Just he filed or he failed to file the affidavit. Just because Bowles is competent here because Spiro did 90% of the work in that hearing on day 3. Kinda, yeah. Ginger Spicy, this guy made me feel sorry for Hannah. Do better. I feel bad for Hannah for the counsel she's had because I feel like she did deserve better. And that I feel like in a better world, she would have gotten maybe cleared, right? It's just I feel like I could have done a better job for Hannah, especially if I'd started out at the beginning. So I just don't know. So Tough Cookie, thank you for the 10 gifted memberships. Fancy RPG, Kelowna meetup when? Also, your mic is weird. Yeah, and I gotta set up a Kelowna meetup. I want to go out there. We'll have to do that. Rainman YYC, blanks are used with the mile system. Yep, the mile system is super cool. And Belle Feinstein, funeral detail also uses blanks. That is fair, because you're not wanting to put rounds into the air. Allison, you need to stop your face. Yeah. Christopher Driscoll, might he also want to take Morrissey off the case so he can call her as a hostile witness to undermine the state's case? I don't think so. I mean, he'd run into a lot of problems on that. Darren Phoenix, thank you for the new membership. And I see Dark Moon Designs. Hi, bye password. I'm in the most dog-dense city in Chicago as a new dog trainer and getting booked and busy after just over a month. Really needed to hear that today. I think you're probably doing awesome. It's just we all have the imposter syndrome stuff. Alita Lay, Morrissey has ADHD with zero tact filter, hyperfocus. Maybe. I don't really like to diagnose, but maybe. Mrs. Kelly, thank you for the heart there. Much appreciated. Okay. Let's see. I don't know if this one is actually the thing we want here.
Your policies are anti-black. You are a disgrace to all black people in this city.
My data.
He's trying to have a press conference, and he's it's not going well.
Day will not change. I will continue to do the job for 8.3 million New Yorkers that I was elected to do. Amen. And I look forward to defending myself and defending the people of this city. We should ask those who are conducting this investigation, we should ask them who gave the directive to carry out what we have witnessed over the last 10 months. Over the last 10 months, you knew information before my...
Did he bring like his religious leader? Like, who's this guy? That seems like I don't like this. Why does he have this crowd behind him when he's doing a press conference? Like, why does he have his hype squad?
My attorneys knew information over the last 10 months. You reported that there was an indictment before my attorneys knew that there was an indictment. Over the last 10 months, this has happened over and over again, and this is not how our system of justice should operate.
Adams solicited and accepted over $100,000 in luxury travel benefits for years from wealthy Turkish business people and at least one Turkish government official seeking to gain influence over him. Adams started accepting undisclosed luxury travel benefits at least as early as 2016. He took these benefits nearly every year through 2021.
The indictment unsealed today.
Okay. That he made some choices. He made some decisions. I don't really agree with those decisions, but they were decisions. Here's the thing. If you're ever indicted, like if I'm ever charged with a crime, the last thing I'm gonna be doing is doing a press conference or doing a like a live stream to talk about my criminal charges. It's just not going to happen. So, yeah, this is messed up. I see Michelle saying, "Can't wait for my hot sauce. Got both. Yay! I'm glad to hear it." And Rainman YOC, this gives me Detroit / Kilpatrick vibes. Yeah, a little bit. The other thing I'm just going to note here is that just on the subject of the hot sauce, Mrs. Runkle, I shared with her that like people are ordering. I sent her a censored image of like the order page, just showing like people are ordering stuff. And Mrs. Runkle was like, "What kind of crazy person orders 4 hot sauces?" And I kind of just had to go like, because I don't know if they're still in here, but yeah, no, I moved all the hot sauces out. I've got like 60 hot sauces in the other room. So I was like, and she's like, "But you don't have 4 of the same thing, do you?" And I was like, "Well, no, but I do have some duplicates." She's like, "Well, you know, this is crazy." And I'm like, "Okay, fair enough." Yeah, I can't ship to the States yet. So yeah. Soon. But not this batch. So all right, let's have a look at the indictment itself. So all right, and so we've got in 2014, Eric Adams, the defendant, became Brooklyn Borough President. Thereafter, for nearly a decade, Adams sought and accepted improper valuable benefits, such as luxury international travel, including from wealthy foreign business people and at least one Turkish government official seeking to gain influence over him. Now, I just want to note, if anyone wants influence over Runkle, I do accept luxury travel. Nobody has offered me luxury travel at this point. But if you feel like it, I accept luxury travel. So yeah. By 2018, Adams, who by then had made known his plans to run for mayor of New York City, not only accepted but sought illegal campaign contributions to his 2021 mayoral campaign, as well as other things of value from foreign nationals. Okay. As Adams' prominence and power grew, his foreign national benefactors sought to cash in on their corrupt relationships with him, particularly when, in 2021, it became clear that Adams would become New York City's mayor. Now, I'm just saying, the mayor. How much power do mayors have? Right? Like, so what can the mayor do for you? Okay. Because like here, my mayor doesn't have a huge amount of power, but maybe it's different in New York. So Adams agreed, providing favorable treatment in exchange for the illicit benefits he received. After his inauguration as mayor of New York City, Adams soon began preparing for his next election, including by planning to solicit more illegal contributions and granting requests from those who supported his 2021 mayoral campaign with such donations. So this is straight up bribery, is the allegations here. Straight up bribery. Eric Adams, the defendant, sought and accepted illegal campaign contributions in the form of nominee or straw contributions, meaning that the true contributors conveyed their money through nominal donors who falsely certified that they were contributing their own money. So the reason why this matters is because the U.S. has a ton of rules about who can donate money. And so let's imagine, for example, that I wanted to, like, let's say I decided that I really love Trump or that I really hate Trump, which seem to be this sort of that seems to be the range of opinions. It's those two options. And let's say that so I want to donate either for, Harris or for Trump or whatever else, right? I can't because I'm Canadian. And so if I try to donate as a Canadian, they're going to be like, no, you can't. And this is the kind of thing you really have to take seriously, because if you violate it, it is a big deal, right? They'll be like, no, somebody's going to jail over this shit. So you're just like, okay, I just kind of want to not go to jail. And the campaigns themselves would be like, we're not taking your contributions. We're not doing it. It's just not happening. So, you might get the clever idea of like, I might, call against the tide and be like, psst, tide, if I send you $1,000, then you could send $1,000 to, to whoever. And, wouldn't that be good? And the thing is, the answer is no, it wouldn't. That is actually a major, a major problem, right? So yeah. Has he called racism yet? Yes. It took him about 8 seconds for him to do that. So, yeah. All right. By smuggling their contributions to Adams through U.S.-based straw donors, Adams' overseas contributors defeated federal laws that serve to prevent foreign influence on U.S. elections. Okay, that doesn't sound like it was all that hard to defeat. It sounds like, in the same way that I might defeat a lock with like a popsicle stick, so, okay. I guess good on you for defeating the super secure system of please don't. I feel like this is not ideal. I feel like this is not perfect. Okay. Wealthy individuals evaded laws. Oh shit, wealthy individuals are evading laws? That's unheard of. Okay, I'll dial the sarcasm back a little bit, but I can only go so far on that. And I'm doing my best. I'm giving it my all here. Just doing what I can. So, wealthy individuals evaded laws designed to limit their power over elected officials by restricting the amount any one person can donate to a candidate. And businesses circumvented New York City's ban on corporate contributions by funneling their donations through multiple employees, frustrating a law that seeks to reduce corporate power in politics. Yeah, who could have imagined that law would get frustrated? Corporations having power in politics? No, they're going to be okay with not having any power. They're going to be fine with that. Adams increased his fundraising by accepting these concealed illegal donations at the cost of giving his secret patrons. I don't think he thought that was much of a cost, but what is it? At the cost of giving his secret patrons the undue influence over him that the law tries to prevent. Now, I'm just thinking he could have saved time. He could have made this a little easier. By just setting up like an actual Patreon, right? With like different tiers. If you donate, if you donate 10,000 a month, then, you can, then you get this access. But, that would have been a little bit more transparency in government. Yeah. Am I being a little too sarcastic? Am I being a little too cynical? Yeah, I feel like my cynicism here is, yeah. Guys, I see you saying order dinner. I just did an order dinner. So dinner is on its way. It'll be here when it gets here. And yeah. So Eric Adams, the defendant, compounded his gains from the straw contributions by using them to defraud New York City and steal public funds. New York City is a matching funds program that matches small dollar contributions from individual city residents with up to 8 times their amount in public funds to give New Yorkers a greater voice in elections. So basically they're saying because he did this thing with the illegal money, that 8 times money is that's theft, right? So Adams' campaign applied for matching funds based on known straw donations, fraudulently obtaining as much as $2,000 in public funds for each illegal contribution. Adams and those working in his direction falsely certified compliance with applicable campaign finance regulations, despite Adams' repeated acceptance of straw donations. I mean, what else were they going to do? No, we are not in compliance. We have done a fraud. They're not going to put down, we have done a fraud on the thing. So relying on the concealed nature of those illegal contributions to falsely portray his campaigns as law-abiding. Again, no shit. Was he ever going to declare that his campaign was, he's not going to put down on the form, I am doing one or more crime. No. As a result of those certifications, Adams' 2021 mayoral campaign received more than $10 million in public funds. Now, I'm just going to say $10 million is a lot of theft. Most of my clients have not managed to steal more than $1,000. So, yep. Eric Adams, the defendant, also sought and received other improper benefits from some of the same co-conspirators who funneled straw donations to his campaigns. What are those benefits? Because I'm hoping it's not benefits. In particular, a senior official in the Turkish diplomatic establishment, the Turkish official, who facilitated many straw donations to Adams, also arranged for Adams and his companions to receive free or discounted travel on Turkey's national airline, the Turkish airline, which is owned in significant part by the Turkish government, to destinations including France, China, Sri Lanka, India, Hungary, and Turkey itself. The Turkish official and other Turkish nationals further arranged for Adams and his companions to receive, among other things, free rooms at opulent hotels, free meals at high-end restaurants, and free luxurious entertainment while in Turkey. You know what? I feel like I went into the wrong line of work because, public corruption seems to be paying really well. Hello, lawful law. Public corruption seems to be doing really well. I have been, of that list of places, I have been to France. And I did not fly first class to France. I flew basically the step above. If I cut my ticket down any more in terms of the fare I was paying, they would have put me in the overhead bin, right? That's the level I was. That's the level of my flights. I have been on a first class flight once in my career. Once in my life, I have been on a first class flight. And that was actually paid for by you guys when I was going to Corey's funeral. You guys paid for a business class flight on the way back. And that was really nice of you guys, but you didn't have to do it, but it was very nice. But that is the only time I've been on I say that I've been on the semi business class, where you don't actually get nice seats, but you are slightly ahead. I've been on the slightly better, slightly nicer economy class, but I've never been on the really luxury things except that one time, and it was really nice. I could fall in love with it. But so I'm already pissed at this guy because air travel destroys my back, just wrecks me. And I'm like, this guy is getting all the free air travel. Why am I not? Also, can I just say, why Turkey? Of all the places I think I'm going to bring down a government on like foreign interference, I don't think Turkey, right? I don't think like, oh, Turkey. So, okay, apparently Turkey is engaged in espionage. Who knew? Eric Adams, the defendant, and others working in his direction repeatedly took steps to shield his solicitation and acceptance of these benefits from public scrutiny. No shit, he didn't announce it. Adams did not disclose the travel benefits he'd obtained in annual financial disclosures he was required to file as a New York City employee. Again, no shit. Sometimes Adams agreed to pay a nominal fee to create the appearance of having paid for travel that was in fact heavily discounted. It's like, no one will ever know that my first class flights did not actually cost $10. Other times, Adams created and instructed others to create fake paper trails, falsely suggesting that he had paid or planned to pay for travel benefits that were actually free. And Adams deleted messages with others involved in his misconduct, including, in one instance, assuring a co-conspirator in writing that he always deleted her messages. Wow. Whoa. In September 2021, the Turkish official told Eric Adams, the defendant, that it was his turn to repay the Turkish official by pressuring the New York City Fire Department to facilitate the opening of a new Turkish consular building, a 36-story skyscraper, without a fire inspection, in time for a high-profile visit by Turkey's president. At the time, the building would have failed a fire inspection. Why do they want to build a fire trap? Why do they want to build a fire? Okay. I guess they just want the building open for business when the president shows up. In exchange for free travel and other travel-related bribes in 2021 and 2022 arranged by the Turkish official, Adams did as instructed. Because of Adams' pressure on the fire department official responsible for the assessment of the skyscraper's fire safety was told that he would lose his job if he failed to acquiesce, and after Adams intervened, the skyscraper opened as requested by the Turkish official. Now, what's a skyscraper worth? What's a skyscraper worth? A lot more than the air travel. So Turkey's actually doing pretty good on this deal. Doing pretty good, right? Doing pretty awesome. So the New York City's Public Matching Funds Program. The New York City Campaign Finance Board oversees and administers a publicly funded campaign finance system for municipal elections in New York City with the matching fund program that they mentioned earlier. So it encourages New Yorkers to, like, they get basically a matching, but it's up to 8 times. So they basically say, instead of seeking large contributions from a limited number of influential donors, and to empower more candidates to run for office, even without access to wealth. So, candidates that collected a minimum number of contributions and raised a minimum number of qualifying contributions from New York City residents were eligible to opt into the matching funds program. And then they were required to file a signed and notarized certification attesting, among other things, that they understood that they were responsible for reading, understanding, and complying with and ensuring their campaign's compliance with various statutes and rules, that submitting fraudulent claims for matching funds or otherwise furnishing false information would constitute a fundamental breach of the obligations affirmed. Oh, really? Committing fraud is illegal? Okay. Okay. And so the matching fund program would provide up to $8 in matching funds for each $1 of eligible contributions, up to $250 from New York City residents. So for each eligible contribution of at least $250, they could collect up to $2,000 in matching funds, and they would provide up to $13 million and up to $14 million in the 2025 cycle. That's a lot of money. Certain kinds of contributions were prohibited entirely, including straw contributions, contributions from a person who was not a United States citizen or a lawful permanent resident, contributions from foreign entities and organizations, contributions from corporations, and contributions that were made, received, solicited, or otherwise obtained in violation of any local, state, or federal law. We cannot do the illegal things. Okay. And they say that they told people that straw contributions were illegal. We're going to skim a little bit here because otherwise we're going to go through a lot of law and a lot of pointless things here. But basically, they're saying he took illegal straw funds. Adams travels to Turkey and begins accepting illegal campaign contributions and personal benefits. I'm just wondering how shady this gets with the personal benefits. Because often when they say like personal benefits in like a filing, often like it's personal benefits. I'm wondering, did they go there? So Eric Adams, the defendant, took 2 official trips to Turkey. His first trip in August 2015 was arranged by the Turkish Consulate General in New York City and paid for in part by the Turkish consulate and in part by a for-profit educational conglomerate based in Istanbul. Thing is, Turkey is not even a good bird. Turkey is the worst bird. And I know they have nothing to do with each other, but still. The second trip was arranged by the Turkish official and a Turkish entrepreneur whose businesses include organizing trips to introduce Turkish corporations and business people to politicians, celebrities, and others whose influence may benefit the corporations and business people. For both trips, he received free business class tickets on the Turkish airline. And he says that he reported both of those things. So cool. So he met with the Turkish official who later did stuff. He met with the promoter who did straw contributions later. He met with businessman 1 who later made illegal campaign contributions. A volunteer, the Adams staffer, who served as his liaison to Eastern Europe Muslim countries, including Turkey. Is it just me, or does like New York have... or does New York have like a whole, like they feel like the government of like Canada, right? Xander says, you're insulting a turkey farmer who's listening. I shouldn't say that. I've had good turkey. I just haven't had good turkey often. And yeah. I'm sorry, Xander. It's just not my cup of tea. So, all right. So, wealthy Turkish businesswoman later gave Adams multiple free or steeply discounted stays in a luxury hotel she owned and organized contributions. So, in 2016, they say he secretly begins accepting free luxury travel. This, I say, is true. Gotta brine your turkey. The problem with brining a turkey is that when you buy like a butterball turkey, it's like pre-packed with moisture and you can't brine it. So if you want to brine a turkey, you have to get like an artisanal turkey from either from the farmer or like some specialty butcher or something. Because yeah, you just can't you can't, like, the grocery store turkeys are gross. And that's Butterball does that. So in 2016, Adams secretly begins accepting luxury free travel. Call me. I will openly accept luxury free travel. Yeah. So in 2016 and twice in 2017, he solicited and accepted free and heavily discounted luxury air travel from the Turkish airline as part of their efforts to gain influence over Adams on 3 separate trips. Adams and his domestic partner traveled to India purchased economy class tickets for herself and Adams on the Turkish airline for approximately $2,000. Okay. 2 days before their flight was scheduled to depart, he accepted upgrades for himself and his partner by the Turkish airline to business class at no cost. Business class is the highest class offered by the Turkish airline. Had they purchased their business class tickets, the tickets would have cost approximately $15,000. Okay, that's a lot more money, right? That's a lot more money. And Xander says, maybe I can bring fresh turkey if you come to the South Okanagan. You might be tempting me. July and August 2017, Adams, a close relative of Adams and a member of Adams' staff, traveled to Nice in France. But Nice is spelled nice. Istanbul, Turkey, Colombo, Sri Lanka, and Beijing, China. Accepted free business class tickets from the Turkish airline, worth more than $35,000 total for himself and his companions. So, on occasion, I have been flown out to places to do speaking engagements, right? To do like Colombo. Is that supposed to be Colombia? Okay. I need to put I need a rider that basically says if I'm going to fly somewhere, you got to fly me like business class instead of luggage class. So, he traveled to Nepal through Istanbul and Beijing, accepted free business class tickets from the Turkish airline for $16,000, free travel benefits worth tens of thousands of dollars. Adams responded in a text message, transferring here, first stop is always Istanbul. When Adams' partner later inquired about planning a trip to Easter Island, Chile, Adams repeatedly asked her whether the Turkish airline could be used for their flights, requiring her to call the Turkish airline to confirm that they did not have routes between New York and Chile. Valuable travel and hospitality. They stayed at the St. Regis Istanbul. St. Regis Istanbul. And they stayed at the Bentley Suite. Portions of which are depicted here. Oh, they've got pictures. And the pictures are complete dog shit. Why are they such dog shit? Okay. We get to see like 8 pixels of the Bentley Suite. 8 pixels. Awesome. They look like really nice pixels, I guess. Let's have a look at something maybe a little better. Okay, so here's the Bentley Suite. You can see it. It's a tiny little thing there. I'm just going to go ahead and say that the Bentley Suite is nicer than my house. The Bentley Suite is nicer than my entire house. So, yeah. In order to conceal the valuable flight, hotel, and other travel benefits that Eric Adams, the defendant, accepted from foreign nationals seeking influence over him, he did not disclose any of these trips on his annual disclosure forms, despite a legal requirement to do so. By law, certain New York, so they're saying basically they got to tell people when they take money. And he says, no, he didn't. No, he didn't take any gifts worth $50 or more. And he was supposed to disclose those things. Okay. Also sought to conceal the luxury travel benefits he solicited and accepted by creating fake paper trails. So he created a fake paper trail suggesting he paid for his 2017 flights, which in fact he had not. So that's even bigger fraud, right? That is even bigger fraud. Yeah. Angela LD. I'm looking for travel suggestions for my 50th birthday next year that are affordable. No Mexico suggestions, please. I don't know if you like warm or if cold is okay, but if you like warm, Costa Rica is pretty good. I liked Costa Rica a lot. If you don't need warm, then I might suggest. I actually like Newfoundland. The east coast of Canada might be quite nice. Mrs. Runkle and I stayed at an Airbnb that was on the east coast, on the beach, and so the beach isn't like nice sunny go get a tan beach, right? It's but there was like cold mist coming off the beach, and we had a hot tub, and it was awesome. So yeah. All right. As Brooklyn Borough President, Adams employed a scheduler who managed his appointments, meetings, and other official events. I do not have a scheduler. The scheduler was used by Adams to perform personal tasks for him, such as collecting rent at a Brooklyn property he owned. So this is the problem: is you can't, if you've got somebody who's hired as a business, like as a political official, you can't connect that. Wolf Chiaro, we're not going to spend too much longer on this. So they're basically saying he's mixing and matching. So yeah, they say pay with his credit card. He says he left cash. All right, so they're saying fraudulent travel. Anything new? Begins accepting straw contributions. He says, I have a $7 million race, have a clear plan to raise it. Each night we're out executing the plan. Solicited, knowingly accepted straw donations. Where's the goodies? Where's the goodies in this case? Are there goodies, or is it just... All right. The promoter stated in part, fundraising in Turkey is not legal, but I think I can raise money for your campaign off the record. The Adams staffer inquired, how will Adams declare that money here? The promoter responded, he won't declare it, or will make the donation through an American citizen in the U.S., a Turk. I'll give him cash in Turkey, or I'll send it to an American. He will make a donation to you. Okay, that is not only a straw purchase, but it is a very clearly spelled out straw purchase. Holy shit. Yeah. The Adam staffer replied, I think he wouldn't get involved in such games. They might cause a big stink later on, but I'll ask anyways. The Adam staffer then asked, how much do you think would come from you? And the promoter said, maximum of 100K. The Adam staffer wrote, 100K? Do you have a chance to transfer that here? We can't do it while Eric is in Turkey. To which the promoter replied, let's think. If you're ever thinking about sending $100,000 super chat, do not send it as a super chat. YouTube would take 30%. Also, I don't think anyone's ever going to send $100,000 as a super chat. Yeah, this is real bad. Businessman 1, they say, sent campaign contributions that they knew, that they knew were a problem. Secretly continued to solicit and accept illegal free shit. More money. 2021 approaches, continues to accept and solicit. There's the Cosmopolitan Suite, all 7 pixels. All right, is there anything in here? Straw contributions from a construction company, $10,000, $10,000. Businessman 4 then offered to write a $10,000 check from his personal bank account. They said that he couldn't donate more than $2,000, but they said that he should direct his employees to contribute and then reimburse the employees. Also illegal. All these, There is so much money on the planet, and there's so much money being spent buying influence and buying power. And if you are the ordinary person, if you're just the ordinary average Jane or Joe, do you really think that the government cares about you if they're doing this stuff? Right? Right? So on August 27th, the university president messaged the Adams staffer that the Turkish university would donate $20,000 to the 2021 campaign by dividing it amongst our employees in appropriate amounts. The Adams staffer responded that if the donation is not more than $25K, then Mr. President, referring to Adams, who was then Brooklyn Borough president, does not participate in person. They then informed him that they would that they'd find more contributions to get to that $25,000 threshold. They were basically told, here's the price tag for the pay to play. And yeah, this is disgusting. I'm going to go over all of this in a filing some other time, because this is 57 pages. It's going to be long. It's going to be long. So Adam Staffer, how much does he owe? Please let them call me and I'll make the payment. Airline manager, it is very expensive because it is last minute. I'm working on a discount. Adam Staffer says, okay, thank you. Airline manager says, I'm going to charge $50. Adam Staffer says, no. Airline manager says, that would work, wouldn't it? And he says, no, dear, $50? What? Quote a proper price. Airline manager, how much should I charge? Adam Staffer says, his every step is being watched right now. $1,000 or so. Let it be somewhat real. We don't want them to say he's flying for free. At the moment, the media's attention is on Eric. So instead of the thousands of dollars, the $15,000 price tag for this, they come up with $1,100 because that looks not quite so fake. Yeah. Adam Staffer, he's also asking where else they can go in Turkey. Do you have a recommendation? And they say the Four Seasons. And Adam Staffer says it's too expensive. Airline manager, why does he care? He's not going to pay anything. His name will not be on anything either. And the Adam Staffer says super. Super. Yeah. Wow. So there's a lot to this. We can go through it on a separate thing, but I just want to say, as a criminal defense lawyer, if you are ever thinking you might be a client of mine, for the love of God, stop putting crime in writing. Stop, no emails, no texts, no cuneiform tablets, no carving it into a tree, no paper, no anything, right? Just don't anything in writing, because when you put all this stuff in writing, it ends up being super easy to convict you. And I feel like assuming that they managed to, assuming that they actually have the evidence that they say, then this is going to be a super easy, I feel like they seem to have a pretty strong case here. And I mean, maybe they're full of shit. Maybe they're, maybe they're not there yet. But like, why are they not having these conversations over the phone and in person? Right? Like, I'm just like, how bad are you, at this? L. Fliggins, bed for me. Thanks for bonus, Runkle. I really needed this. You're a wonderful shot of pure. Why do we do this? Thank you. That is really appreciated. And if I recall correctly, at one point, like I thought you, if I'm remembering the right person, I thought you sort of came in hot at one point. And so, if so, if I'm thinking of the right person, glad to have sort of won you over there. But yeah, this is such a weird job sometimes. And I just try to share the good parts of it along with, all of that. So Tomato Cheek says, because people don't talk on the phone anymore, text and emails is the way. Here's the thing. I love texts. As a guy who is just like nervous as hell, I love sending text messages and, because then you can avoid the whole conversation thing, right? I'm like, yeah, this conversation could have been 2 texts. But I'm not involved in crime. I'm sending texts to my wife like, hey, I'm going to order some food. What kind of food? Like, would you like any food? And you know what? Her saying, hey, is there some way to get like a smoothie here? Is not ever going to be used against me in a criminal prosecution, right? They're going to be like, oh shit, Runkle got a snack for his wife. Send him to jail, right? That is just not going to be a thing. But if I was trying to crime, I would be on the phone all the time. And I would be on a different phone every time because I would have like burner phones in my freaking budget, right? It would be like every time I need to have a conversation, it would be like new phone. So, yeah, I just don't get it. Okay. So more, I'm just trying to see if there's anything like super exciting here. Super exciting. And it looks like it's just a lot of travel. Oh, there's a summary page here. Free upgrade to business class for 2. Free business class tickets for 3. So whoop. I accidentally lost the page. Just when I found a good page, I lose it. Just when I found a good page, I lose it. Okay, here we are. So 12,000, 41,000, 16,000, 12,000, 9,000, 21,000, 12,000. Okay, so all of that adds up real fast. Okay, so let's wrap that up because I have to go to the door because I think that there is I got food at the door and you can hear the pup. The pup's got opinions. So I'll be right back. Yeah, we're going to do this one. I hope that mic was off. And I was like, oh, good, the mic is off. Because, yeah, I may, whoop, and I got to turn my camera on. Hey, folks, I may have brought my food in going hot, hot, hot. And, yeah. All right. Okay, so what do we want to cover next? Chat, we got a couple more topics I wanted to cover today. So we got Karen Reed as one topic. And we've also got Diddy. And we're going to be at this a while. And I'm going to snack as we do. Somebody says, what's for dinner? I got Chinese and I got a bunch of dim sum. So I got like these little dumpling things. I am always I'm always amazed at some of the stuff that sort of is food universals. And those food universals seems to include dumplings and meatballs, meat on a stick. All of those are, yeah. So I am seeing Diddy and Reed both about equal. That is that is a thing. Let's go with Diddy. And the reason why is I saw one person made a suggestion in the chat that I thought was an excellent suggestion, which is basically that we can look at Diddy now and we're going to hate our lives less when we read Reed at the end. Because Diddy is awful. Diddy is one of the worst people ever, and at least by the allegations. I mean, even if the allegations aren't true, it's awful, but an equality, you're in Alberta? Me too. If I manage to arrange a meetup, I expect you to be there. So you'll have to be there if I get that going. Apple Silver is saying, tell us the story about the neighbors laughing at you. I can do that. I ordered a new gun safe, right? And the gun safe is heavy. The gun safe is super weighty. So Mrs. Runkle was not feeling good. Mrs. Runkle was not feeling amazing. So she was like, I'm having a nap. And I'm like, okay, cool. I'm going to try to move this gun safe into the garage. And I'm going to try to do it without like requiring you to help Mrs. Runkle because she was sick and she was not feeling great. Now, a gun safe is a great big monster thing, right? It's a great big heavy thing. And so I'm there and I've got a hand truck to help cart it. And I'm trying to get it down the stairs because this was the other thing. The delivery guy was delivering this safe. And I got on my video doorbell and I told him not to pull it up the stairs. And he pulled it up the stairs anyway. He was like, screw you. I'm putting it up the stairs. And I was like, fine. So I'm trying to cart this thing down the stairs and I'm having difficulty. And then I get it finally down the stairs. And I then I'm like wheeling it through the grass to get around to my garage. And I'm struggling because this thing is super, super heavy, right? And I'm trying to make sure it doesn't like fall and crush me. Because if it falls and crushes me against the tide would be like, Runkle, I told you you're not allowed to die. So But I see the neighbors are across the street and they're laughing at this. And I'm like, okay, fine, whatever. It is a thing. But the neighbor woman there from across the street, she goes into the house. And I'm like, okay, fine, good. She's not laughing at me anymore. Excellent. And then she comes back out with like 5 other people from the house. And they're all laughing at me. She got the rest of her family out so that her whole family could laugh at me. And I'm like, are you fucking kidding me right now? Like, I'm just sitting there trying to move this safe, and I can hear, like, you know, there's like 6 people pointing at me and laughing. And yeah, nobody offers to help. Nobody is like, hey, we can help you out. They just laugh. And I was like, all right, in fairness, it is kind of hilarious. But also, like, a little bit up yours, because that was such a jerk move. So I get finally the safe into the garage, and now it's, you know, that's where it's located, and it's just used to store ammo. But yeah, I was like, wow. So yeah. So if you see a video on YouTube of like guys struggling with giant safe, it might be me. So This had bones in it. That's not good. Was I in a unicorn onesie? No. I was in proper clothes. So, yeah. All right. Let us have a look at Diddy. Nope, that's not Diddy. I need to actually pull Diddy up. So, now that Diddy has been A, sued, and then B, charged, he is getting C, sued again. And the thing is that it's gonna be Bab's board games. We've not gotten to Karen Reed yet. So the thing is about suing him now is that if he gets convicted on the criminal files, fantastic. Oh, I see people swoop. What's a good swoop? Good swoop, good swoop. Where's the doggo? That is not the doggo. Yeah. All right. So we're gonna go through this filing, but one of the reasons to sue when somebody's been charged is that if they get convicted, then the lawsuit becomes easy, because if they've been convicted of committing the offenses that make up the lawsuit, you can typically use the conviction as proof in the lawsuit. And the reason why is because the standard of proof on the conviction is higher, right? So, all right. Yeah, do not pet the murder dog. So, plaintiff Thalia Graves, by and through her attorneys, alleges as follows. By the way, I just want to note here, there's lots of different law firm names out there. Lots of different law firms. And some of them have been joke names, right? I can't eat that on stream. It's too bony. I'm going to look unpleasant. Okay. So, you know, you've always heard of like the law firm of Dewey, Cheatham, and Howe because, you know, it makes for a good joke. The law firm of Cutie Hecker Wang. Cutie Hecker Wang is a law firm name, and it's an actual law firm name. It's not a joke. And I'm just like, oh, okay. Okay. Now, that might be the last time we really get to laugh as we go through this one, because this one is awful. Now, I will say sometimes I use humor to help with horrible shit. Right? And it is what it is. So please don't judge me too harshly if I have to laugh at some things, because that's kind of how we cope. So I'm not trying to like denigrate anybody or to diminish their experience. It's just some of this is gonna be god awful. So in or around summer of 2001, plaintiff's life was violently knocked off course when defendants Sean Combs and Joseph Sherman viciously raped her at the Bad Boy Record Studio in New York City. I am not going to run the New York City clip, but I thought about it. Plaintiff was 25 at the time and dating one of Combs' employees, a relationship that Combs exploited to lure plaintiff into meeting him and Sherman alone. Once they successfully sequestered plaintiff, Combs and Sherman gave plaintiff a drink, likely laced with a drug that eventually caused her briefly to lose consciousness. She awoke to find herself bound and restrained. This is messed up. Combs and Sherman proceeded to brutally sexually abuse and violate plaintiff. Fair warning, this is going to be bad. We're going to roll a banner here. We're going to roll a clip. For the people who want to know when they're done or when this is done, you can throw it on mute. And when you see the content warning end banner, then you know it's safe to unmute. That is an option, right? But we're going to see some of the allegations, and this is going to give us a preview, unfortunately, into what the criminal charges are going to be like. And the criminal charges are going to be awful. So Combs and Sherman proceeded to brutally sexually abuse and violate plaintiffs. Combs mercilessly raped her anally and vaginally. Sherman forcefully slammed plaintiff onto a table, slapped her, and repeatedly thrust his penis into her mouth. Both men were undeterred by plaintiff's cries for help throughout the attack. The sad thing is, based on what seems to be coming out about Diddy, it may actually not be that he was undeterred. It may actually be that he liked the cries for help and so forth. That could be what because the allegations here seem to be that he is into the power and dominance. And yeah. Plaintiff never recovered from defendant's violent rape. She had suicidal thoughts and ideation and has received extensive psychological treatment because of defendant's attack. That itself will generate evidence there. For decades, she remained silent and did not report the crime out of fear that defendants would use their power to ruin her life, as they'd repeatedly, explicitly threatened to do. To this day, plaintiff suffers from severe depression, anxiety, and panic attacks, and still lives in fear of defendants. Here's the thing. They got away with things so long because people were unwilling to report. And for each of the people, it can be a rational decision not to report. I am not judging them for not reporting. It can be a fully rational decision, and also it can be just beyond people's ability to do, right? But one of the things that is worth considering, one of the things that is worth thinking about if you are ever in this position, and I hope none of you are, but is the possibility that you might be saving somebody else if you make the report. And you may never know who that is, right? You may never learn who didn't get assaulted based on that. And yeah. Katie did it, says, hi, Runkle. I'd love to see a live stream with you, Rob, and Emily, just like the good old days, possibly discussing the juror interviews afterwards or highlight the retrial. Any chance? Unfortunately, I don't think so. I don't think there's much chance. Me and Rob will be on most Fridays, but I don't think that's likely to happen, unfortunately. So, any progress plaintiff had made in healing from the attack over the years was dramatically reversed on or around November 27th, 2023. God, how does this get worse? It gets worse. When she learned for the first time that Combs and Sherman had video recorded the horrific rape 22 years before and had shown the video to multiple men seeking to publicly degrade and humiliate both plaintiff and her boyfriend. And I really hope that that video burns them. So, yeah. Plaintiff could not believe that the defendants would record themselves committing such a gruesome crime and then proceed proudly and widely to disseminate the recording of it. She was distraught and sunk into a deep depression. She again considered ending her life. I'm just going to address this. Suge Knight said that on Cuomo that Diddy himself was raped while being raised. Here's the thing. Not a fucking defense. Because there's plenty of people who have been through horrible shit who didn't feel the need to visit that shit on anyone else. I'm not going to go into specifics, but I've been through some shit in my life. Some awful shit. And what that leads me to do is not go out and hurt people. It's to go out and try to help people. Because I don't want anybody to go through shit. I don't want anybody to suffer. And I think there's lots of people out there who are like me, who are like, hey, I've been through some shit. I want to help. I want to make there be less shit out there. And these fuckers are out there making the world a dark fucking place. These are the fucking storybook monsters that, you know, that need to be defeated. So, yeah, Suge Knight, if you're saying that, you know, that was okay because of what he went through, fuck you. Fuck you. And the thing is I just don't understand that at all, right? Even if you just suffered minor harm, right? Like, let's say you slam your hand in a car door, right? And you're going, ow, fuck, that really hurts. Is the first thing you want to do to go and slam someone else's hand in a car door? Maybe if you're a jerk, or maybe, You want to figure out a way to make the doors safer, right? Maybe you want to figure out a way to make sure no one else has that problem. Yeah. So, yeah. This action seeks redress for defendants brutalizing, misogynistic, and violent attacks on plaintiff, starting in 2001 with their rape and continuing in the subsequent years as they compounded her humiliation by showing the video of the sexual assault to others. Now, you might be saying, is there a crime that people could be charged with for the for seeing this video? Unfortunately, the answer is probably not. It depends, right? So, where could they charge him? If there's revenge porn laws and they shared that video on to someone else, then they could potentially be charged, right? That's itself an offense. If they are a mandated reporter, which there are some, then that could be, an issue. Someone says, could they be an accessory after the fact? An accessory after the fact is somebody who helps, right? And there's a difference between not helping versus, or doing nothing versus helping. So, in most places, and I say most because there are some places where this is different, then you don't have to do anything if you see a crime or if you see somebody get injured. Right? Let's say I walk out of my house and I see, a nun get run over by a drunk driver. Just flattened. And she's dying. I am not required to go help her. I'm not required to call the ambulance. I'm not required to do anything. Now, I would, right? But I'm not required to. And if legally speaking, if I turn around and go back to bed, then I'm in the clear. Now, you'll note that I said legally speaking, right? Legally speaking, I would be in the clear. There's a big difference between that and morally speaking, because I would like to think that most people would be a little bit horrified if they, if they didn't do something there. Let's see. There's another one that I will note here, and it is one of Niven's laws. And I'm just going to, it's phrased in a way that might be a little offensive, so I apologize, but Niven wrote this in like the 60s. So, sign of the times. But the way he put it, and I agree with the sentiment of it. I don't agree with the way he phrased the law, but the way he phrased the law is, old age is not for sissies. And what he means by that, he then elaborates on it and he says, think before you take the coward's choice. And what he means by that is that in your old age, you will have to look back at your life and live with all of the decisions you made, whether to do the right thing or not do the right thing, right? And I hope that at some point in your old age that you are able to look back at your old age and to say that I did the right thing when I needed to, right? That you can say, I was the person who stepped up. when people were looking around saying somebody ought to do something, you were the person who was like, you bet, let's do it. Right? But that's not necessarily true of all people. And I don't know that there will be legal consequences for the people who watched those videos and did nothing. I don't know if they're going to go to jail, right? I doubt it. But I really, really hope that that they live long lives, and that every night of those long lives, that they sit there late at night and they think, man, I am a piece of shit. I should have done something. Right? I hope that this fucking haunts them. So, and the thing is they're probably not the kind of people who will be haunted by the things they could have done. I get haunted about things I could have done, even in situations where I couldn't have done shit. Right? I just get haunted about the fact that there is this much misery in the world and that I don't have a way to fix it. And that I just feel like I'm not doing enough to try to make the world a better place. So, but I hope it haunts them. And I also hope that their names, oh, somebody else got there just as I was getting to it. I hope their names get broadcast. I hope every single person involved is known by everybody. I hope we all get to know whether they are like who was getting off to this shit, right? So I hope we know, right? I hope we know. So parties, plaintiff Thalia Graves is a female who resides in Harris County, Texas. Defendant Sean Combs is a male who, on information and belief, resides in Los Angeles County, California, though at the time of filing was incarcerated in the Metropolitan Detention Center in Brooklyn. They had to amend that, I think, from their initial draft. The fact of Combs' ownership and titles at the Combs Corporations enabled him to commit the unlawful sexual violence against plaintiff described herein, and or to harass and subsequently intimidate her into silence after the rape. Why do they tie in the corporations? Why do they tie in the, those that his corporations enabled it? Well, it's because they want the money from the corporations, right? They want that money too. Defendant Joseph Sherman, a.k.a. Big Joe, is a male who, on information belief, resides in Westchester County, New York, employed by Combs and or the Combs Corporation, and they say that his titles enabled him to do things, etc. This, in hindsight, is super gross. Actually, it was probably pretty gross beforehand, but it's extra gross now. Defendant Daddy's House recordings. Defendant Daddy's House recordings. They named their company Daddy's House. Gross. Gross. Yeah. So that's a company owned by Combs, and yeah. Defendant Combs Global they're saying it's an alter ego for Combs, basically saying that they want the money out of it. That's why they're doing that. As part of his renowned bad boy record label and brand, Combs has established several corporate entities under the Bad Boy name over the past few years or past few decades, including but not limited to Bad Boy Entertainment Holdings, Bad Boy Production Holdings, Bad Boy Books Holdings, Bad Boy Records, Bad Boy Entertainment, and Bad Boy Productions. Together, Bad Boy. So he's got Daddy's House, and he's got Bad Boy record label. I just kind of feel like he was kind of trying to tell the world. And, yeah. Like, all of this looks super awful after the fact because it's like, oh, it's always the guys you most suspect. Is really what this is coming down to. So organizational does 1 to 10 are other entities that they say are, owned or employed by Combs or Sherman. So they're basically saying we want to add companies as we discover them. So each of them aided and abetted Combs and Sherman in committing the unlawful sexual violence against the plaintiff, and/or in harassing and subsequently intimidating her into silence after the rape. Provided Combs and Sherman with the studio and office space where they committed the rape, and/or with chattel, that's stuff, including recording equipment, storage equipment, etc., to record the rape and disseminate it. And are alter egos for Combs, completely dominated by him and used for his personal interests and to engage in wrongdoing which harmed plaintiff and others, and/or serve or is served as vehicles for Combs to move, dispose of, and/or insulate his assets, including in connection with his criminal activities, and to avoid compensating the victims of his many crimes, including plaintiffs. So they're basically saying, we want to be able to come after the corporation, the corporate money, and so forth, right? Oh, crud. Mic problem. Can you hear me? Okay, hopefully you guys can hear me. Hopefully the mic fuzziness is gone. So, yeah. Jurisdiction and venue, basically they're saying this is why the court can hear it. Jury demand. She wants a jury. Excellent. Factual allegations. Again, this is going to be a little rough, but it is what it is. Plaintiff's family immigrated to New York City when plaintiff was a teenager in connection with her mother's work. Her family ultimately settled in Rego Park, Queens, where she completed her education and where she was living when she met Combs. So, yeah. Defendant Combs, also known by his stage name, Puff Daddy, Puffy, P. Diddy, Diddy, Brother Love, or Love. Again, creepy AF, right? Creepy AF. That, the brother love stuff. So, yeah. He rose to fame in the 1990s with his record label Bad Boy and continued to be a notable figure in the music and entertainment industry in the following years. Combs has continued to amass wealth and power through his business ventures in the music, fashion, fragrance, beverage, marketing, film, television, and media industries. The Bad Boy enterprise is the foundation of Combs' wealth and power. Bad Boy has sold over 500 million records through its lucrative distribution deals with the top music companies in the world and has signed acclaimed hip-hop and R&B artists, including the Notorious B.I.G., Mary J. Bilge, and Usher. Combs later founded Combs Enterprises, etc., which does music, fashion, beverage, marketing, film, television, and media industries. Combs Global houses Bad Boy and other notable businesses such as Combs' fashion line, Sean Jean, his vodka line, Ciroc, and his cable media company, Revolt Media. I can tell you, I will drink literally any other vodka before I drink Ciroc. So, in that light, I will quite proudly take a pull of a vodka I would rather drink than anything associated with Diddy. Whew. Medicine-y. Yeah. Whew. Yeah, I'm feeling that. That sort of has a an interesting feeling all the way down to the stomach. So, yeah. As detailed below, Combs had a long history of violence and abusing and raping women, and there have been several civil lawsuits filed against Combs in the past year alleging sexual violence and abuse. On September 16, 2024, Combs was arrested and charged with racketeering and sex trafficking. He was denied bail. How good does that feel? I bet Gloria Allred really enjoyed, enjoyed writing that. Defendant Sherman, also known as Big Joe, was employed by Combs and his bodyguard and head of security during the relevant time period described herein, and served in various roles in the Combs corporations. Okay. Sherman is also the founder of Rhymes and Dimes magazine, a New York State registered corporation. I just lost the lid to this. Do I have another lid here? Oh, awesome. And through in connection with that company, produces... Wait. Chat. How does this keep getting worse? He's got a porn company. How come this keeps getting worse? That he's got a company that produces and distributes porn. On information and belief, he has often distributed videos of his and / or his friends' sexual assaults through his pornography company. Oh, Jesus. Jesus. Somebody's asking, what happens with the lawsuit that he lost by default? He's actually managed to have that default reversed. So that has already been reversed. Plaintiff met defendant Combs in or around late 1999 or early 2000 through her then boyfriend, who was an executive at Bad Boy. In addition to working together, plaintiff's boyfriend and Combs had a close personal relationship. Plaintiff frequently visited her boyfriend at the Bad Boy studio in New York City and attended events hosted at Combs' residences. Over time, plaintiff became familiar with Combs, and he knew about her relationship with her boyfriend. No, I did not read this in advance. I have been massively busy, but also I kind of wanted to react to this one as we go. Defendants trick, drug, and violently rape plaintiff. In or around summer of 2001, plaintiff received a call from Combs concerning her boyfriend's employment at Bad Boy. He told her he wanted to meet with her in person to discuss her boyfriend's supposed performance issues. Her boyfriend was determined to climb up the ladder at Combs' record label, and as his romantic partner, plaintiff was committed to helping him. She agreed to meet with Combs. In retrospect, it was evidently a sick and twisted way of using his ownership of and title at Bad Boy and its affiliate entities to abuse plaintiff and also show his power and his ability to humiliate her boyfriend, his executive. A few hours later, Combs arrived at plaintiff's mother's residence in Queens with Sherman, who was employed by Combs as his bodyguard at the time. Sherman was driving an SUV and Combs was in the back seat. After plaintiff entered the vehicle, Combs offered her a glass of wine, which she accepted. So if you happen to be in prison with Diddy right now, and if he offers you a glass of Pruno, do not drink Diddy's Pruno. Combs began discussing his alleged concerns about her boyfriend's performance at work. Meanwhile, as plaintiff drank what had been handed to her, she started to feel lightheaded, dizzy, and physically weak. In retrospect, it is clear that Combs had caused a drug to be put into plaintiff's drink, as a few sips of wine had never impacted her that way. Combs and Sherman drove plaintiff to the Bad Boy studio in Manhattan. When they arrived and plaintiff tried to get out of the car, she realized that she was feeling odd and found it difficult to walk. She assumed this was her fault and did her best to act normal and followed Combs as he led her eventually to a couch in a private room in the Bad Boy studio. She later came to understand that this was Combs' personal lounge and office at the Bad Boy studio. Kind of their casting couch? Combs sat on the couch next to plaintiff and continued speaking with her. Plaintiff began feeling even more woozy and sedated. She then lost consciousness. When plaintiff regained consciousness, she was naked and her hands were tied behind her back with what felt like a plastic grocery bag. Plaintiff shouted for help. In response, Sherman lifted her up from the couch and forcefully slammed her face down on what was apparently a pool table. Shortly thereafter, Combs entered the room naked. Combs reached for a container of a lubricant that smelled like menthol and proceeded to apply it to his penis. Okay, this is getting even worse. He then bent plaintiff over the table, causing her feet to dangle above the floor, forcefully held her down, and penetrated her without her consent. Plaintiff is 4 foot 11 inches tall and weighed only 103 pounds at the time. Plaintiff was unable to move, totally overpowered physically, in addition to being drugged and bound. This is a very, very serious set of allegations here. We're going to skim. Allegedly slammed her head during this. She says she vomited into her mouth and on the table. Involuntarily defecated. She says she experienced intense pain and burning sensations, extreme pain, lost consciousness, and more forcible things. When she next awoke, she was on the couch naked and alone in her room. She was in severe pain and distress. Her parts burned, her face and wrists were bruised, and her genital area smelled strongly of menthol. She felt a liquid dripping out from inside her. Her dress was thrown over her, her purse was on the couch next to her, and her bra was on the floor nearby. She did not see her underpants. So, terrified that they would return, she got dressed and bolted out of the studio room. And still dizzy and weak, she called a livery driver that her family regularly hired and knew well. Driver picked her up from outside Bad Boy Studio. She was disheveled, crying uncontrollably, and suffering from agonizing pain. I suspect that driver is going to end up being called as a witness. Driver drove her to the hospital and tried to convince her to report the rape and get a rape kit, but she was unable to leave the car, shaking and crying hysterically, and terrified of what Combs would do to her and her family if she reported him. Good for him for trying. Like, good for him for trying to help, right? So plaintiff suffered serious injuries. She had burning, bruising. Afterwards, she had bleeding and hemorrhoids. She was afraid to report. She was involved in a contentious divorce and custody battle and feared that reporting would cause her to lose custody of her young child. Plaintiff confided in her boyfriend, hoping that he would comfort and support her, but he discouraged her from disclosing the assault, telling her that it could negatively impact his own career. What a sack of shit. What a sack of shit. Following the assault and multiple times over the years, they contacted her and warned her to be silent, threatening repercussions against her potentially losing custody of her son. And she was afraid that they could follow through on their threats. She told close friends that they had drugged and savagely raped her, but was afraid to report the attack to the police. Because of that, she was afraid to even stay in New York while Combs lived there, so she fled to Pennsylvania. And she's relocated multiple times throughout the years in an effort to stay away from Combs. Irreparable harm in the form of severe depression, post-traumatic stress disorder, suicidal ideation and negative thoughts and intrusive thoughts, and has attempted to end her life. lives in constant fear, struggles with hypervigilance, and experiences anxiety and panic attacks in social settings, preferring to be alone. Her need to hide to feel safe has strained her relationships with friends and family. Also has impacted her ability to engage in sexual acts with her intimate partners. To this day, she cannot be in sexual positions without experiencing flashbacks of Combs. All right, I think we're past the worst of it. I'm gonna roll this. I think we're past the worst of it. We'll see. So on around November 27th, all the trauma of things came flooding back when her former boyfriend revealed that Combs and Sherman had recorded and published the video. Cassie Ventura came forward and filed a lawsuit. The case had been settled one day after it was filed. And yeah, when they settled the day after it's filed, she's got some, that lawsuit was something that terrified the shit out of them, right? Yeah. Plaintiff's former boyfriend invoked Ms. Ventura's effort to hold Combs accountable and for the first time confessed that years earlier, but sometime after the event itself, Sherman and Combs had shown him and a group of men, some of whom were also employed by Combs' companies or their related entities, the video of plaintiff being attacked. He disclosed that Combs and Sherman had a pattern and practice of non-consensually recording women engaging in sexual acts and making those videos available to the public, including by selling tapes as pornography. A Bad Boy artist later corroborated in a text message that Sherman used to sell porn of him doing this to chicks, and that Sherman did that to a lot of women. Her boyfriend is an absolute sack of shit. If he knew that was going on and was okay with it. And I see people saying puppy cleanse. You know what? I think we need both puppy cleanses. Potter has been a little sick. He's been a little unhealthy, and yeah, it's not the greatest. I hope he gets better. Zora is starting to catch it, but they're both so cute. So when I go down to take a nap, Zora comes by and she's like, "I'm going to use you as a pillow. You get to be a pillow." So yeah. Plaintiff's former boyfriend reported that he and other men watched the recording on a handheld camera while at the Bad Boy studio, and some of the other men made derogatory comments about the former boyfriend's relationship with her in an attempt to shame him into cutting ties with plaintiff and cause her further emotional harm and embarrassment. Continued to show the video to others over the years and to the present, and /or sold the video as pornography. Plaintiff was shocked and horrified that they'd recorded and publicized the video. After over 2 decades spent trying to heal, she was devastated by the news. She felt as if her life had been turned upside down. Again, we're skimming over the worst bits. It is censoring it a little bit, but it is what we're doing here. She felt as if her life has been turned upside down again, and like the things had been happening again and again as she was trying to forget it. She experienced acute psychological distress, plunging into a deep depression and having suicidal ideations. She felt intense fear, anger, and anxiety. I can't blame her for any of that. Plaintiff lives with the distress of knowing that the video of things is in circulation and that anyone, including her family, friends, and peers, could view it at any time. In a panic, she reached out to Sherman after learning about the tape, hoping to protect herself from further humiliation by convincing him to destroy the tape or provide it to her, but he did not respond. Combs' pattern and practice of violence and abuse, including of drugging, attacking, and secretly recording his violence against women. Combs has a long history of violence and abuse. This long-standing behavior has been enabled by his ownership and titles of the Combs corporations to tie that into the lawsuit. Among a long list of allegations, in 1996, he was found guilty of criminal mischief for threatening a photographer from the New York Post with a gun. In 1999, he was arrested and charged with second-degree assault and criminal mischief in connection with the beating of a record executive, and arrested again the same year in relation to a shooting at a club in New York. That female victim has consistently stated that Combs shot her in the face at point-blank range. How does he still have the ability to get guns? Yeah. Combs also has a pattern of and practice of using his power and influence in the music and entertainment industries to submit people to sexual violence, often drugging his victims or coercing them to consume drugs and recording the assaults, often without the victim's knowledge, just as he did with plaintiff. So in the past year, a number of these people have come forward to accuse him. So in November 2023, 3 lawsuits were filed against the New York Adult Survivors Act. Joy Dickerson-Neal, who had appeared with him in a music video, sued him for the same kinds of things. Liza Gardner sued him for events when she was only 16. December 2023, an anonymous plaintiff sued in the Southern District of New York for attacking her when she was only 17 years old. Said that they lured her to Daddy's house through their affiliations with the Bad Boy Enterprise and attacked her at the same location where plaintiff was attacked. Rodney Lil Rod Jones, one of Combs's former producers, sued for forcing him to engage in unwanted sex acts and sex trafficking, among other allegations. Says that Combs regularly drugged others, including minors, by giving them alcoholic beverages laced with ecstasy and other date rape drugs, and that he believes he himself was drugged by Combs, and that Combs routinely secretly recorded sexual encounters. 2 more women sued him. Former adult film star Adria English sued him. Dawn Angelique Richards sued him. Part of the girl group Danity Kane, I don't know them. Arrested at a Manhattan hotel after a grand jury indicted him on charges of sex trafficking and racketeering. So the allegations are not just that Diddy is a rapist, but also that he's, he's going after children. Yeah, that's, he's a special piece of shit. Yeah, that, yeah. Okay, carrying on here as we go. Let's see. Notes that Combs' abuse of women was enabled by the employees' resources and influence, the multifaceted business empire. Notes that Combs' business was operated at various times in both Manhattan and LA. Physical abuse was recurrent and widely known. A lot of this is rehashing all of the allegations that we've already been through, the charges. So first cause of action, violation of New York City Victims of Gender Motivated Violence Protection Act. So basically they say crime of violence be committed because of gender or on the basis of gender, due at least in part to an animus based on the victim's gender, is satisfied because of the sexual assault. So gender animus inheres when consent is absent. His long history of violence against women evinces a deep contempt for women, as does Sherman's alleged pattern of committing his own sexual assaults, recording them, and selling them as pornography. I feel like pornography is not the appropriate term when you're talking about a recording of like an attack. But I don't know what the other term is here. The attack caused a serious risk of physical injury and in fact caused injury. Corporation was involved, so they're tying in the corporation to make sure they can go after the assets. Suffered an amount to be determined at trial and pursuant to the fee shifting provision of the statute. So basically they're saying if she wins on this, then the attorney's fees are covered by Diddy. Right? So, yeah. Basically saying Diddy should have to pay the lawyers as well. Second cause of action, violation of civil rights law. Disseminated the video without her knowledge or consent. She was fully identifiable in the video. Had a reasonable expectation that they would not record the video. Fair. That intentionally publicly humiliated her for the purpose of, causing her harm. Malicious, willful, wanton, and outrageous, awarding her to an award, entitling her to punitive damages. Defendants should be ordered to account for and destroy all copies of the video that are in their actual or constructive possession, custody, or control. Here's the problem. If a single copy of this ends up on the internet, there's no way to make it go away. Just none, right? You just can't get this kind of thing off of the internet. Third cause of action, violation of Administrative Code 10180. So this is disclosure of intimate images without her consent. So basically, this is called like a revenge porn law, but I really hate that term, because it doesn't appear that this was revenge. The reason why I hate the term revenge porn as a thing, and I wish that we would kind of make that term go away a little bit, is first, revenge implies a wrongdoing, right? You get revenge for somebody wronging you, right? Like if somebody sets fire to my house, I might go and get revenge. And there's a ton of movies around the theme of revenge, right? And she didn't do shit to them, right? Like she's not out. They weren't out for revenge against her. They're out to hurt her. And I also don't like that, like porn, in some cases of like the revenge porn, in some cases that ends up being like that the videos and images were taken consensually, but then the distribution was non-consensual, right? But here the video wasn't recorded consensually at all, right? So yeah. So intentionally disclosed and disseminated to then boyfriend and others, including selling it, and to cause her economic, physical, or substantial emotional harm. So they say we want punitive damages. We also want all copies of the tape and permanently enjoining them from disseminating any intimate images. They want compensatory damages in an amount to be determined at trial, punitive damages in an amount to be determined at trial, attorney's fees and costs, pre and post judgment interest, attaching any real property. So basically saying that they can claim against the real property, ordering defendants to account for or destroy all copies of any images or videos, and awarding such other and further relief as the court may deem just and proper. So, yeah. And yes, Gloria Allred is on this file. How much to bankrupt Diddy? Lots, unfortunately. But I hope they get there. And I think that ends this one. We're going to roll this again. So I'm not going to look at Gloria's press conference. I watched it. I don't know that Gloria Allred is really pulling any weight on this one. I just don't know. But and I'm not going to play the press conference with Diddy's lawyer. Diddy's lawyer does say some shit, though. Diddy's lawyer says that Diddy is eager to testify. And I'm like, are you now? Are you now? Because if I was Diddy, I would not be keen to testify. Diddy's going to get slaughtered on the stand if he testifies. It's going to be just absolutely awful if he. But Diddy's lawyer was also asked about the 1,000 bottles of baby oil. 1,000 bottles of baby oil. He was asked about that. And his response was to say, well, Diddy's got a big house and he buys things in bulk. And there's a Costco in every town that he's got a house in. So he's probably just buying in bulk. Epic Diddy is wrapping up. So, yep. So that was the dumbest thing he could have said. And Costco has responded to this. And Costco has said, we don't sell baby oil, asshole. He did not buy the baby oil from us. So, no is what they said. They're like, nope, get our name out your MFing mouth. And I think we're actually going to see more brands doing this because you remember during the Depp trial, you remember that Depp trial, Amber or Elaine got up and was like, this is the, this is what she used to cover, that. And the cosmetic company posted something going, no, she didn't. She did not use our shit because it didn't exist then. The Milani makeup palette. They're like, no, she didn't. That is not true. So I feel like we're going to see more brands coming out to be like, that's not true. Yeah. I saw a news story today, something like 12 to 19 brands pulled out on him. If I was in any way doing business with Diddy, I would be setting fire to that business relationship so fast. So fast. So, yeah, so fast. All right, so that is the end of that one, and I think we're all a little bit glad that that one is done. So somebody asked me, would I want to go to watch Diddy's trial? And the thing is I want to see, I would want to see Diddy cry when he gets sentenced to forever in jail. I want to see him break down and beg the universe not to let this happen to him. That I absolutely want to see. But I don't want to watch the trial. I don't want, and the thing is if you're sitting there watching this trial, they're going to roll tapes. And I hope to God, I really hope that the court is going to clear the courtroom for when they play the tapes of the actual attacks. Judge, make it the fuck happen. Do it. Because nobody else should have to see that shit. But you're still you'd still hear witnesses telling what Diddy did to them, what all of this. So yeah, it's federal. We're not going to see it broadcast. But some people were saying, would you go down to watch this trial? And I'm like, God, no. No, this is not what I want to know. So I just want to hear that Diddy is, assuming he did it, which it appears that the evidence is really, really going to be good. It appears that they've got strong evidence against him. I basically think they should brick him into a cell and slide food through a slot. And that's it. Fuck that guy so fucking hard. And also fuck everyone in the industry who knew about him and didn't do shit. Fuck all of his friends. Fuck all of them. I hope that this trial is the trial that just keeps on trialing, because I hope that this trial, ends up being like dozens and dozens of people, where they just, dozens of people where, they just keep charging them. Runkle, did you hear right now Diddy and SBF are cellmates? That can't be true. That can't be. I don't think that's actually true. But if they are cellmates, I really hope that both of them resort to cannibalism. I really hope that both resort to cannibalism. Chris, I may have lost that email. Please resend and I'll try to respond. Ah, crap. Mike is doing the static thing. 1 second. All right. Hopefully, yeah. Same dorm. Okay, that's different. But yeah, Sam Bankman-Fried has the possibility to do the funniest thing. So yeah. I won't say the things I hope happen to Diddy, because yeah. I just, yeah. Oh yeah, and Sam Bankman-Fried's former girlfriend got 2 years. That is a good deal for her. It's a good result. So she got 2 years. She's going to be out. She's going to be out and cleared. And, well, not cleared. She's going to be out and has a record. And I'm okay with the 2-year sentence for her. I think that's not inappropriate. I think that is okay, because her assistance helped out with all of that. Okay. Galena Ward says, I zoned out for 2 seconds and came back to cannibals. Little bit. Yep. Little bit. Tyranny, random question. Ian, what's your favorite gun? I really like shooting my M3K, the Stoger. I like my Luger. I like my CZ Shadow 2. I like lots of things. Fifi is my name-o. No foreign influence allowed in elections. Yep, correct. Fine Ape 1393. Hope when you can ship to the US, the lime is ready. Working on it. I'm hoping to have a new one out called Lime and Punishment. So, yeah. Missy DD Moo, we're not done yet. H Scorpio, U.S. Supreme Court says bribes are okay as long as paid afterwards. Not getting there. Equality, long time no see, guys. Runkleism is as strong as I remember. Well, it's good to see you, Equality. Good to see you. Grant Horn, cynicism's okay, sarcasm acceptable. Thank you. H Scorpio, don't forget about the NYPD cops working overseas. Yeah, that's the whole thing. Scott Roach, I love turkey, and I hate I know what you mean. Fair. Jackie Lindy, New York City is U.S.'s largest city and port, home of Wall Street, most diverse city, home of the UN, etc. Fair. Fair. Kirsch McCallum, what if I say for legal purposes, this text is a joke, everything mentioned is alleged? No. Those are not magic words. Equality, thank you for the 5 gifted memberships. Much appreciated. Rosebud26, enjoying Eminem ripping on Duty in new album. I will have to listen to that. Katie did it. Thank you so much. Brissy Girl, I have a couple of items to auction for extra life. Shoot me an email or send them to my P.O. Box. Conacy, thank you for 5 gifted memberships. Tomorrow I got to go to my PO box. So yeah. So Chavera, rather drink the juice of an actual rotten potato. Yes. And Patty P, get wrecked, boyfriend. Yep. And Galena Ward, I zoned out for 2 seconds and we can back to cannibals. It kind of happens. So so tomorrow I have packages I got to ship. I'm just covering up addresses, but I got packages I got to ship. So those are, but I also have to go to the courthouse because I have to file some documents and appear in a courtroom. So I'm going to be arguing some issues in court and yeah. And then after that is done, I'm going to be going to the post office and hopefully, well, I'm going to come back and mail a bunch of shit. And then hopefully I am going to, send a bunch of packages out. So I got like 30 packages to send. So, and who knows, maybe more by the time all of this is done, but I got a whole bunch of packages to send. All right, chat, how tired are we? How tired are we? Jamestown, Friday Night Frenzy is not happening tomorrow. I have the inside scoop on that. I know Rob is doing a thing, so it is not happening tomorrow. And yeah, what is it? I see people saying I can go longer. Okay, we can go longer. We can go longer. We can do this. I am not dead yet. I am okay. I'm all right. So, Julia 543. So could we talk more law tomorrow night? We could, potentially. There's a case I might want to go over. And that case is a Smith & Wesson case. So, we could do that. That is a thing we could do. The other thing we could do, is Karen Reed is 77 pages. It's 77 pages. It is not short. So we can either keep running right now and we'll be at this for a while, or we can go through Karen Reed tomorrow. I am fine with either. But I think a lot of you have been waiting for Karen Reed. So let's do it. Let's just do it. Because I think a lot of you have been waiting for Karen Reed. And so I feel like I would be blue balling you if I did not. And so let's do it. Let's do it. All right. So brief of appellant Karen Reed. We can do a deeper dive into the mayor tomorrow. The other thing I'm going to mention, there's a story that is weird out of the whole Karen Reed thing. It is that apparently somebody apparently left some ducks, rubber ducks, like yellow rubber ducks, outside of a restaurant that is like vaguely connected with things. Oh, Patty Hoffman, have COVID and appreciate the snark tonight. Well, shit, I'm sorry that you've got COVID. And I'm going to roll a swoop here because you guys are saying swoop. Little puppy. Okay. So, somebody left some rubber ducks that have FKR written on them. And so, people are basically saying, like, apparently Bukaki is, like, demanding to, like, is trying to figure out who left these ducks and is, like, all of this. And I'm just like, seriously? Like, okay. I don't know if the duck thing has any special meaning. But he's upset that it's free Karen Reed. Content warning over swoop. No, we're past the content warning. We're on to Karen Reed. Okay. Let's have a look here. So 77 pages. 77 pages. 77 pages. All right. So, I feel like this is one of those places where you're just like, brevity. Brevity. Oh, Jackson said the walks like a duck, talks like a duck. It's a duck thing in emotion. Gotcha. Am I going to Peace River for the 3-gun match this weekend? No, I'm not. I think I have other things to do. Oh yeah, they left it outside Chris Albert's place. Okay, fair enough. D&E Pizza. Okay. All right. So let's have a look at this. Statement of issues presented. Whether the jury's final unanimous agreement following trial that Ms. Reed is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy purposes and precludes trial on those counts. Now you might be saying, why are they saying it in this questioning way? And the reason why is that the statement of issues is a portion of an appeal brief that is required in a lot of places that basically just says, these are the questions we want the court to answer, right? These are the questions we want the court to answer. Living Like a Cat says, who is Rob? He is Law and Lumber. And where is Friday Night Frenzy streamed? It is streamed on Law and Lumber's channel. I often pop in there and, you know, so you'll often be able to see me there. So, whether Ms. Reed was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her on counts 1 and 3. Whether there was a manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1, the jury was not deadlocked and in fact had reached a unanimous agreement on those counts. 2, the trial court provided no opportunity for Ms. Reed or her counsel to be heard regarding the declaration of a mistrial. And 3, the record reflects no consideration of alternatives to a mistrial, when in fact such alternatives existed and were codified in the law. Why do they say manifest necessity? Manifest necessity is the legal standard, right? And so manifest necessity for a mistrial prevents double jeopardy from attaching. And the manifest necessity essentially is that manifest necessity is, is triggered in situations where you have like a hung jury. You can't proceed if you've got a hung jury, but you can also have manifest necessity in other circumstances that are not a hung jury. Let's imagine, for example, that like they order lunch for the jurors at like, Bob's Pizzeria. And unknowns to anyone else, Bob's Pizzeria is next to a chemical plant, and chemicals get into the pizza, and the jurors get fed these pizzas, and they all die, right? They go in, the jury retires to deliberate for the day, and then they, they knock on the door, and they're like, how you guys doing with that verdict? And the jury, and like every single one of the jurors is dead face down on the table, right? At that point, you've got manifest necessity for a mistrial. Obviously, you cannot have a trial where everyone is dead, right? I feel like that is, I feel like that's a thing, right? So, yeah. Whereas if they have a mistrial where there isn't manifest necessity, then that can trigger double jeopardy and prevents a new trial. So, statement of case. On June 9th, 2022, Ms. Reed was charged in 3 separate indictments with second-degree murder in violation of the law, manslaughter while operating under the influence of alcohol, and leaving the scene of a collision resulting in death in violation of other law. A jury trial began on April 16th. Court declared a mistrial July 1st. Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending 1, that the jury reached a final unanimous decision to acquit her on those charges, and 2, that there was no manifest necessity supporting the mistrial given the evidence that the jury was not deadlocked, but was instead in agreement on those counts. As set forth in more detail, infra, fuck you. Sorry, I'll explain why in a second. The motion was predicated upon affidavits by counsel reflecting statements of 5 deliberating jurors that the jury had agreed Ms. Reed is not guilty on the relevant counts. So, what does infra mean? Infra just means below. Below in the page. You know how hard it is to say below? Zero hard. It has 5 letters. B-E-L-O-W. 5 letters. Infra, I-N-F-R-A. 5 letters. So those 5 letters can go fuck themselves because Latin is... Stop it. Now, often in citations, people will say, please see supra note whatever, right? And infra, note whatever. I fucking hate that. Every time I use a citation, I just repeat the citation, right? Rather than going infra note 7. Because in the modern era, we're not short of ink. We're not short of, it's not like these things are being hand typeset and that you have to do, so just repeat the citation. And I've had people tell me that's not correct. You have to, whatever. And the thing is when I went to the Supreme Court, my citations, I repeated the citations every time. Every time. And you know what the Supreme Court said about this? Fucking nothing. Nothing. Whereas the Supreme Court will reject your filings for the smallest, tiniest technical bullshit. They will bounce your filings. And if they didn't bounce my filings for not using supra and infra, then they're cool with it too. And I see people saying, but you're short of pages and maybe it's to keep the page limits. The thing is, it takes the same number of lines to repeat the citation as it does to say infra or supra. So, yeah. And of course I'm going to mention the Supreme Court, but I feel like they're correct on, Anyway, I hate supra and infra, and this just irrationally pisses me off when he throws in infra. It just makes me mad for no reason. And stop it. Stop it. I'm guessing you hate further the affiant saith not, too, Ian. Yes, I do. It is so dumb. Because you know what? If the affiant was saying more, they would just say more. You know how we know that they're not done or that they're not saying anything else? Because they're not saying anything, right? Okay. After hearing oral argument on August 9th, oral argument is way less interesting than it sounds. The trial court issued an order denying Ms. Reed's motion to dismiss. The court accepted, for the purposes of the motion to dismiss, that the juror statements quoted in the defense affidavits were true and accurate. It went on to hold, however, that because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. The court similarly rejected the defense argument regarding lack of manifest necessity, finding that Ms. Reed's counsel consented to a mistrial via their failure to object, and the jury notes reflecting an impasse established the requisite manifest necessity. Okay, that's just a pagination thing. Finally, the court rejected the defense's alternative request for a post-trial inquiry on the grounds that Ms. Reed's argument did not implicate racial bias or her right to receive an impartial trial, and because it believed that the request implicated the substance of the jury's deliberations. Ms. Reed's retrial is currently scheduled for January 27th, 2025. Now, I am going to, I'm probably going to be at SHOT Show around then. I'm probably going to be in SHOT Show. So I don't know that I will be able to cover the beginning of this because I'm going to be off doing gun shit. And that is just kind of my life. So, yeah, we will see. So, statement of facts. On June 25th, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors you should continue deliberating until you have reached a final verdict on each charge. It also noted that count 2 contained lesser included charges of involuntary manslaughter and motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. The following day, on June 26, 2024, outside the presence of the jury, counsel for Ms. Reed raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Ms. Reed not guilty, before going on to ask whether Ms. Reed was guilty of the offense charged or guilty of one of the 2 lesser included offenses. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2. The trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions telling jurors that count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. On June 28th, 2024, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. The court asked counsel for their views on whether there had been due and thorough deliberation sufficient to support the giving of a so-called Tui Rodriguez charge, also called the dynamite charge. The Commonwealth responded that the charge should not be given because there simply hadn't been sufficient time yet. Counsel for Ms. Reed disagreed, requesting that the court read the Tui Rodriguez model instruction and go from there. The trial court sided with the Commonwealth, ruling, I'm not prepared to find that there have been due and thorough deliberations at this point, so I'm going to send them back out. And then later, they sent another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Ms. Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the court gave the instruction. Later that day, the jury sent yet another note. The jury's like, stop, we're already dead. Right? That's really what the jury's doing. Thereafter, without reading the note to counsel and without providing the counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges, the trial court simply stated the jury is at an impasse and called in the jurors. It then read the note on the record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Basically, stop, let us go. We want out. This is the equivalent of like when Zora goes to the back door and scratches because she's like, I want out. I want out. I gotta pee. I want out. Like, I want to run and chase some birds. Like, that's really what the jury is saying here. Like, we want out. Let us out to pee. Let us out to chase birds. Let us out to, all of the things. And yeah. After reading the note and without soliciting the views of counsel in any respect, the trial court stated, I am not going to do that to you folks. Your service is complete. I am declaring a mistrial in this case. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. By the way, Zora is sufficiently destructive that Mrs. Runkle and I have had to rebuild and reinforce our back door. It has large steel plates on it now so that Zora can't claw her way through it. We had to replace the doorknob so that she couldn't get through. Zora is an absolute escape artist little shit. And we love her, but holy shit. So the following day on July 2nd, unsolicited by any party, one of the jurors contacted one of the attorneys for Ms. Reed, Alan Jackson. Juror A, yeah, I've heard this. The jury thought the Trooper Paul was more credible than the ARCA engineers. That is fucking ridiculous. Because Trooper Paul was an absolute clown show. Juror A stated that they wished to inform Attorney Jackson of the true results of the jury's deliberation. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1. Juror A was emphatic that count 1 was off the table and that all 12 of the jurors were in agreement that she was not guilty of such a crime. They also unanimously agreed that she was not guilty of count 3. One day later, another attorney for Ms. Reed, David Yannetti, was contacted by 2 different individuals who had received information from 2 distinct jurors, both of whom were part of the deliberating jury in this case. Informant B sent attorney Yannetti a screenshot that they had received from someone of text messages that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B: "It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose." Juror B later placed an unsolicited phone call to attorney Yannetti, confirming that the information contained in the publicly filed affidavit was accurate. Juror B clarified, however, that they meant to write, "No one thought she hit him on purpose or even knew that she had hit him." Juror B further told Yannetti that she believed every member of the jury, if asked, would confirm that the jury can reach not guilty verdicts on 1 and 3. C had been in contact with another individual. I'm going to skip past a little bit of this. Because this we already know, right? We already know that the jurors basically said, we want to dismiss 1 and 3. They totally discounted ARCA because they thought Turtle Boy hired them. Oh, Jesus. So the Commonwealth filed a post-trial notice of disclosure informing the court that ADA Lally received an unsolicited voicemail on his office's phone line from an individual who identified themselves as a juror by full name and seat number. So again, confirming this. So summary of argument. Alexandra Baginski is saying, love from Germany. I want to go back to Germany one day. Germany was awesome. How are you still live? Caffeine. Good morning from Finland. I've never been to Finland. I have been to Norway, and Norway is beautiful. I assume Finland is as well. I would love to visit Finland one day. Also, Finland has a fine tradition of handing the Soviets their ass, and therefore Finland is awesome. So, summary of argument. The very day after the trial court declared a mistrial, counsel for Ms. Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors, indicating that they had a firm and unwavering 12-0 argument that Ms. Reed is not guilty of 2 of the 3 charges against her. Including the charge of murder in the 2nd degree. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from one juror to the same effect, nor the Superior Court judge, who expressly accepted the veracity of juror statements relayed in affidavits by counsel, disputed the factual basis for the defense motion in any meaningful respect. So basically, everyone seems to agree that everything is so okay. But the thing is, the arguments the defense was making is essentially that that it's not that it doesn't matter. That's what the prosecution was arguing. I'm just now for the Finns who are in the chat. I really do want to go there, but I think you guys also have salmiak, and before I visit, I will need you to get all of the salmiak out of the country because I can't do the salmiak. Yeah, I'm gonna get some shit for that, I think, but let's keep going before the Finns for the Finns riot. So salmiak is salty licorice. It is not for me. It is not for me. So, all right. Despite the widespread media given to the defense filing of the attorney affidavits attesting to the jurors' representation, they'd acquitted Ms. Reed of 2 of 3 charges. No juror disputed the facts represented by the attorneys in any manner, i.e., nobody came out of the woodwork to say, hey, this is bullshit. We wanted to convict on everything, right? Nobody said that they wanted to, we're all set to convict. So, that is its own thing. All right, so let's keep going here. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes reprosecution of Ms. Reed on counts 1 and 3 and mandates dismissal on those charges. This presents an issue of first impression for this court, as does the defense's alternative contention that Ms. Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court precedents permitting such inquiry regarding claims of external influence and / or juror bias should be extended to the present context, i.e., this just makes sense, right? And now you guys have me looking at Finnish foods. Apparently there's a salmon soup that's a Finnish food. I would eat the hell out of that. Also, spring potatoes and pickled herring. I would eat the heck out of that too. All right, but people are like, what is salmiak? It is like salty licorice. It's weird. So yeah. All right, let's keep going here. Independently, while a jury deadlock constitutes manifest necessity to support a mistrial, there is no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respect to all counts. And the problem is that there's just not really case law on this because nobody's ever had this issue come up, right? Nobody's had this issue come up. And the guy who eats surströmming is mad at licorice. The surströmming was actually good. I liked the surströmming. I would eat surströmming more if it didn't cost like $100 to get a can shipped here. But I would eat it if I was in Sweden. So, put another way, there was no deadlock as to 2 of the counts on which the trial court declared a mistrial. The trial court's finding that Ms. Reed's counsel had consented to the mistrial is contrary to both the factual record and the clear binding case law. The trial court, in its opinion, erroneously failed to apply clear state and federal law, or federal case law, that places the burden of establishing manifest necessity solely and exclusively on the prosecution rather than on the defendant. I'm supposed to look at Mammy. Mammy, Finland. What is Mammy? It is a traditional dessert. It is rye porridge. That doesn't look bad to me. Doesn't look awful to me. The trial court also failed to address the 2 guiding principles set forth by this court in Stewart and Taylor, that before a mistrial is declared, counsel must have been given full opportunity to be heard, and the trial court must have given careful consideration to alternatives to a mistrial. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designed to encourage a verdict, with consent to a mistrial. In sum, whether the jury acquitted Ms. Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result: dismissal. So, I want to say a couple of things here. One, I think that the odds of this winning are low. I don't think they're going to win. But damn if they're not coming out fighting. This is really well written. I like the writing on this. I think it is really well written. I think that they've done an excellent job writing this. And I am impressed. I'm impressed so far by the writing. I think that they're probably dead in the water, and I think it's unfortunate that they're dead in the water on this one. But I think that is the case. Gun show this weekend in Stony Plain. Okay. I may have to check that. So I think they're likely to have to go for a retrial on all 3 things, but yeah. Time for a European snack package for Runkle. I would not say no to that. And somebody says, would you eat lutefisk though? I have eaten lutefisk because my grandmother was very Norwegian. She was very Norwegian. And so I've eaten lutefisk, and lutefisk is fucking awful. The other thing I have eaten that I don't much like is brunost. I'm not up on the Turtle Boy stuff yet. I might cover Turtle Boy tomorrow if I'm able to do a stream. Brunost is it's like a brown cheese. It is not good. So, yeah. So, argument. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. So, what they mean by this is the U.S. has a different tradition of jury nullification than Canada does, but also says that no matter what, like the government might convince the judges and so forth, but ultimately a jury isn't under control of the government, right? The government doesn't get to control a jury. And so if the government, so the jury basically is the will of the people. It is the people's opinion on things, right? And so the people are are able to express their voices. And the other thing is that the protection against double jeopardy, when you look at the bottle shock, twist my rubber arm, I would eat fat grubs and roux steaks. So when you when you look at the U.S. Constitution, a lot of the U.S. Constitution is reactionary. And what I mean by that is that a lot of the U.S. Constitution is basically because of abuses that existed in, pre-United States. Because of that, they put in certain protections. And so that's why you get protections saying you can have free speech, right? And that's why they get protections saying you can have guns. The guns thing was literally to shoot the British, right? So, that's why they said it was important to have arms, right? So that you can shoot the British. And I mean, fair ball, right? As former British colony, fair ball. But they also put in restrictions to say that you need to protect the right against double jeopardy. And the reason why they said you need to protect the right against double jeopardy is what they used to do. One of the abuses that used to happen in sort of pre-America was that they would they'd try a guy for a charge, right? They're trying this guy for sedition or whatever the fuck, right? And the guy gets acquitted. And then they'd try him again for the same charge. And they just keep trying until they could finally convict them, right? And so finally, after they eventually convict them, they're like, cool, now this guy goes to jail forever or gets executed, right? And so because that happened in pre-America, they said, no more. This cannot happen again in our new best country that we're building, right? Because that was really the idea they had, was that they were building the best country ever. Like, we're going to build a country that will have no problems. It'll be perfect. Everything will be great. And that's they did okay, right? They didn't nail it. They didn't entirely stick the landing, but they did okay. They did pretty good. The U.S. has done pretty well. I like the U.S. So yeah, they basically said, we're fixing all of these problems. So these things, there's a lot of case law basically saying these things are super important. So they quote here, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. So, two things. When you are citing to like the U.S. foundational documents in the U.S., like all of this stuff, right? When you're citing to all of this stuff, it is super, super impressive, right? Doesn't that sound super awesome and super cool? And you know who does this? You know who cites to those original classic things? Losers. And you're probably going, Runkle, what the fuck? The reason why I say that is because typically if you've got a better argument, you cite to that. Whereas when you've got a losing argument, you cite to the ancient historical shit. And so, unfortunately, I don't think this is winner talk, right? I don't think this is winner talk here. And I hate to say it because I really think that they ought to like in a better world, they would win on this one. But I think in the world we live in, they're not going to. And yeah, somebody said I need to stay in an igloo hotel. I'm looking it up right now, and I totally do need to stay in an igloo hotel. But they're so far away. But I so want to. If I ever start making like big money, like, you know, I'm pretty sure like Lawyer and Emily are making way more cash than I am. At least I hope to God they are. If I start making like that kind of money, then I will fly to Finland and have like stay in an igloo hotel and do a live stream from an igloo hotel. Cause yeah. All right. So the double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and powers, should not be allowed to make repeated attempts to convict an individual for an alleged offense. So, even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which they are stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an individual to stand trial. The thing is that the in Canada, we have a double jeopardy clause, but it's different, and they can get retrials on appeal. And the thing is that in Canada, what we've seen sometimes is you get somebody who's like charged with murder most foul, or like murder 75% most foul, or whatever it is, right? And they're facing like all of this, and the government has virtually unlimited money. Like the government can put like 4 lawyers on the matter, and and has access to experts, and they have all of this, right? All the money, all the power, all of this. And the defense is probably like mortgaging their house and, scraping together every penny that they've got in order to run this defense, right? In order to be able to run this trial. Whereas the prosecution can just keep going forever, because you know what never runs out? What never ever runs out? Taxpayer money. Taxpayer money never runs out. And so you see, like trial 1, the defense has like some ace lawyer. And then trial 2, they've got an okay lawyer. And then like trial 3, they're self-represented. And guess what happens? They get convicted on trial 3 because they've just had their funds run down, right? And then you go, well, did the person actually do it? Or did they just run out of money and can no longer present a competent defense? And yeah, so yeah. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. The court reviews determinations regarding double jeopardy de novo. What does it mean to review it de novo? It means that there is no deference owed to the prior decision, right? That there's no deference owed. So, yeah. Oh, my God. If you ever come to Finland, you'll have to try a wife carrying competition, Nokia rubber boot throwing, and maybe swamp football. My wife is taller than I am. And it's not like a little tall. She's taller. She's substantially taller than I am. And she's got like, multiple inches of height on me. I am not going to win a wife carrying competition because she can carry me, but not the other way around. We'll have to swap that around, right? We'll have to flip that over because, yep, no. So they note here, what constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some of all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Okay. Here, the affidavits by Jackson and Yannetti reflect statements by 5 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed is not guilty of counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberation. So they quote them again here. In rejecting Ms. Reed's claim of acquittal, the court relied solely upon the lack of an open and public verdict affirmed in open court. This reasoning is rooted in a formalism that has been consistently rejected by the United States Supreme Court and this court in a string of precedents spanning more than 100 years. See supra, fuck off. See above, page 22, citing cases. Now, I just want to note here that they also say just days ago, an article was published online reflecting an interview with an anonymous juror quoted as saying, it was very clear on charge 1 and 3. Murder was decided on day 1. She did not have an intent to murder. Citing to Aidan Kearney, Canton Coverup, part 397, Karen Reed juror says they switched on manslaughter verdict, confirms murder acquittal, says jurors couldn't ask Judge Cannone questions about 2 verdicts. They're citing to Turtle Boy. Right? So, yeah. Turtle Boy gets the shout out. So, what is it? However it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. So indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. And in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of 5 jurors quoted above did not, in fact, represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Instead, they would predictably have notified the Commonwealth or the court of their own recollection. Here, to the contrary, the Commonwealth received the exact same information. So, yeah. Yeah, give me 1 second. I got a cable that's wiggling loose and it's making noises there. How good can I play air guitar? Not very well. Somebody is saying, can Vera Staleka, would they sponsor? Maybe. I don't know. I don't know if Vera Staleka would sponsor or not, but I'm bad at reaching out to potential sponsors. Although I did reach out to a laser engraver company to be like, hey, can we make a deal? And they're probably going to be like, hey, go fuck yourself. But it still helps. I guess it helps to ask. So Donnie says, do I answer my emails? Sometimes. I sometimes answer my emails. I'm bad at it. I've got emails sorted into basically like this needs to be answered right away because it's like a client or some shit like that. And yeah. I got an email right now. I will try to respond it here, and I will try to yeah. All right. So Supreme Court decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when they remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. This case does not sound great for the defense. In doing so, the court relied heavily on the lack of finality in the juror's report. The jury's deliberations had not yet concluded. Okay, this is better. And it went back to the jury room to deliberate further. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations. It was still the case that all 12 jurors believed that the defendant was not guilty of capital or first-degree murder. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following. Let's talk about how you deal with shitty case law. Let's talk about how you deal with shitty case law. So let's say I am researching I'm researching for a case. I'm going to be arguing it. And either I find or the other side finds a case that just says, Runkle, you are screwed. Your argument is no good. You're going to... So I got a few options. I got option number one, which is that I can try to find other cases that have overruled that case. I can say this is bad law. Or option number two is I can say my case is different from that case. So you shouldn't apply that case to my circumstances because that case doesn't really connect to this one. So, yeah, that's kind of the thing there. All right. So the contrast with a juvenile is even clearer. In that case, after the conclusion of trial, a court officer found 4 verdict slips in the deliberation room, 2 of which reflected entries of not guilty. There was no indication as to when the entries were made or in what circumstances, much less that they reflected a final, unanimous conclusion of all jurors. So neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because such a final unanimous agreement was not announced in open court. Similarly, you have no cases on the other side. Yeah, not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that they were, when we were silent when we shouldn't be, but she was acquitted. The instant case squarely presents this issue, and the defense respectfully submits that this court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. This issue is one of existential importance, not merely to Ms. Reed, but to the very foundation of the constitutional safeguards that protect her. Okay, so basically saying, throw those charges out because this stuff is, because they came to the other thing, right? Okay, cool. Yeah. Also, Donnie, just from your email, I love the saying that you have from Germany. I'm just going to note the saying there. Even the smallest animal shits. That is an awesome saying. So alternatively, the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the juror representations as to having acquitted Ms. Reed. So basically, they're saying if you don't think that the jury's necessarily, came to the direct, to the verdict, bring the jury in. Bring the jury in. And once the jury, and then we can ask them one after the other. Did you all agree? Does everybody agree on this? Right? So that's what they're asking for here. So they say the trial court was wrong to artificially limit the right to a post-trial inquiry to develop a substantial claim of a constitutional violation to the narrow context of claims implicating racial bias or the right to receive an impartial trial. This court has not framed the availability of post-trial inquiries so narrowly, instead stating, we will permit juror testimony regarding overt factors by which the verdict's validity can be objectively assessed, such as extraneous influences on the jury, but not regarding the subjective mental processes of jurors, such as the reasons for their decisions. And, I mean, Murdaugh is going to raise its ugly head again here. Murdaugh is kind of relevant. Why is Murdaugh relevant? Well, because in Murdaugh, they brought jurors in to ask them not about racial bias, but about did Becky meddle? Did she tamper? Right? So in Fiddler, this court rejected the Commonwealth's suggestion of an inflexible rule excluding all juror testimony offered to impeach verdicts as achieving stability at the expense of doing justice between the parties. Instead, the court ruled where the defendant's claim is predicated upon the presence of overt factors, the law's commitment to a just result warrants receiving evidence, but where the juror would testify solely to matters resting in her own consciousness, the dubious value of the testimony is outweighed for the need by the need for stability in verdicts. Okay. So Fiddler expressly recognized that the line between overt factors and matters resting in a juror's consciousness is not easily drawn, and difficult cases will arise, but went on to observe, we think it possible to draw the line in most cases, and in any event, the better course is to try to do so rather than to refuse to try. So the law is clear that in the context of juror bias, an affidavit by counsel is sufficient to entitle the defendant to a post-verdict inquiry. We're going to skim a little bit, I think, because it is past midnight. Bottle Chalk offering to send drop bears. So we'll skip over a little bit of this, basically saying we've got a right to, let us talk to the jury. Bring the jury back. Let us ask them the questions, right? Let's ask them the questions. So the defense respectfully submits that the court should hold the presence of an unannounced verdict supported by the unambiguous post-trial statements of 5 deliberating jurors constitutes an overt factor, at least entitling the defense to further inquiry. So what they're hoping, of course, is that if they bring the jury in for further inquiry, that the jury is going to say, yeah, we were all ready to acquit on those counts. So in Sarnev, this was the Boston Marathon case. They remanded the matter for further proceedings in the Boston Marathon bombing case due to 2 jurors' postings on social media regarding the bombings and the district court proceedings, which came to light after the jurors had been provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. Comments were also inconsistent with the jurors' assurances that they had not discussed the case online. So the first district held that the district court erred by failing to inquire about these issues with the jurors. So, yeah. So they ordered them to voir dire those jurors, and in doing so, the court acknowledged no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. All right. So in another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alex Murdaugh that during his murder trial, the clerk of the court improperly influenced deliberating jurors. Becky Hill. Becky Hill is fucking up so many cases. Becky Hill isn't just meddling with Murdaugh's case, but now she's also playing a role in Karen Reed's case. Becky Hill is everywhere. Becky Hill is like under your bed. Becky Hill will, attack you while you're sleeping. Becky Hill is the the clerk allegedly told jurors after the defense began its case not to let the defense throw you all off or distract you or mislead you, and warned them not to be fooled by Mr. Murdaugh's testimony in his own defense. The trial court held an evidentiary hearing on the motion for a new trial, including testimony by jurors. As with Sarnev, the issue was not racial bias, but nonetheless implicated fundamental constitutional rights, like Ms. Reed's right not to be retried for offenses of which she has already been acquitted. So, yeah. Trial judge dismissed Ms. Reed's reliance upon Sarnev and Murdaugh in a brief footnote, stating simply that the circumstances are readily distinguishable from those at issue here. If they're readily distinguishable, then distinguish, right? You got to explain how. You don't just say that they are, right? So, yeah. But this misses the forest for the trees. While it's certainly true that all three cases raise different issues, the fundamental point remains the same. A defendant who comes forward with credible evidence of a serious constitutional violation post-trial must be entitled to an opportunity to prove those claims. They say there's no apparent reason to artificially limit the availability of such constitutional inquiry to the singular context of racial bias, as the trial court suggested. They also say that this doesn't impinge upon the substance of the jury's deliberations. Now, the substance of the jury's deliberations is like, why? Why did you want to convict, or why did you want to acquit, or what did you think about? What did you think about Trooper Paul's, evidence? What did you think about that? Right? Like, did you like him? Did you not like him? Those kinds of things. They're not allowed to do that, right? But they point out that the relevant inquiry could be accomplished by a single yes or no question posed to the jurors. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3? And of course, the results of a jury's deliberations are not secret. They are, in fact, routinely announced in open court. So basically, it would have been announced in open court if they'd actually asked the jurors, right? Yeah. All right. Skipping ahead a little bit more on this one. So indeed, it was the trial court, not the defense, that injected issues regarding jury deliberations into the inquiry. It is simply not true that given the content of the jury's final note to the court, any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. So, as explained in light of the trial court's instructions, the jury's note is readily susceptible to interpretation consistent with the post-trial evidence supporting the defense motion. And in any event, if the jurors state that they acquitted Ms. Reed, no further inquiry regarding the contents of the jury note could possibly remove the clear constitutional implications of such acquittal. They're basically saying, we need one question. One question, right? That's it. One question for each juror. That's all we need. Make it happen. Okay. Reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. So basically they're saying because they were acquitted on this, they don't get another kick at the can. We're going to skip over this one a lot because we've heard it before, and we're going to skip over and yeah. They note that the burden of establishing manifest necessity is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard, and they must have given careful consideration to alternatives to a mistrial. Here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel, i.e. they just, everybody go away now, right? Everybody go away now. All right. The defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of the law, which were to request that the jury be polled or discuss the issue with Ms. Reed. So they basically say, because of the importance of double jeopardy protections and the profound implications of a retrial for criminal defendant, an opportunity to be heard must, in according to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. So counsel for Ms. Reed clearly had no such opportunity here. Whether or not the trial court was obligated to obtain Ms. Reed's personal consent, its failure to at least ensure that counsel had an opportunity to consult with Ms. Reed on the issue undermines the existence of manifest necessity. So, and they say that the court did not make any careful consideration of alternatives to a mistrial. And the alternative is basically, tell us what things you were deadlocked on. Was it everything or was it nothing, right? Okay, skipping ahead a little further. So, in denying the motion to dismiss, the trial court erred by relying primarily upon the lack of objection by defense counsel. In doing so, it utterly neglected to acknowledge the clear and long-standing case law placing the burden of establishing manifest necessity squarely on the prosecution. Nickel provides a helpful analog. Nickel was charged with operating a motor vehicle under the influence of alcohol. Only 6 jurors were impaneled, and after trial began, one juror recognized a witness and informed the trial judge that he might not be able to be impartial. The judge excused the juror. Left with 5 jurors, the judge and attorneys briefly discussed how to proceed. Defense counsel expressed his frustration over the impanelment of only 6 jurors and then stated, "I don't think we can go forward with 5 jurors, can we?" The judge responded, "Not in a criminal case. Okay, I'm going to declare a mistrial." After a retrial was scheduled, the defendant moved to dismiss on double jeopardy grounds. The trial judge allowed the motion, finding that contrary to his initial understanding, Massachusetts procedural rules would have allowed the trial to continue with 5 jurors, albeit with defendant's consent. The judge therefore found that he had failed to give careful consideration to the alternative of proceeding with the trial before less than a full jury, and accordingly, there had been no manifest necessity for the mistrial. So, on appeal, this court began from the premise that due to the importance of jeopardy protection, the Commonwealth bears the heavy burden of proving that a mistrial rested on manifest necessity. The court then agreed with the trial judge that the defendant could waive his right to a trial by jury of at least 6. It rejected the Commonwealth's argument that the defendant in the case at hand had not provided such a waiver, observing, the question is not whether defendant executed a valid waiver, but whether there was a manifest necessity for declaring a mistrial. Such a necessity would have presented itself if defendant had declined to execute a waiver, but the record is clear that neither judge nor counsel was aware of or even considered the option. In these circumstances, the Commonwealth was unable to satisfy its heavy burden of proving that there was a manifest necessity for declaring a mistrial. So let me break this down a little bit. This case that they cited and described that we read, like that they read the description of, right? They said basically, it was up to the prosecution. It was up to the prosecution to know that they could have proceeded with 5 with a waiver. And because the prosecution didn't raise it in that case, the prosecution didn't get to have a retrial. So he's saying, like, it wasn't our job to ensure that the manifest necessity thing was dealt with. it was their job. It was the prosecution's job, and therefore it's no manifest necessity here. So they say the argument is the same. Neither Ms. Reed nor her counsel consented to the declaration of a mistrial. Consent may be implied where a defendant had the opportunity to object, but failed to do so. But the law is clear that such consent may not be inferred from counsel's silence alone. And basically they're saying the judge just rushed through this, right? Just rushed. So, yeah. The trial court's ruling that Ms. Reed's counsel impliedly consented to the mistrial was based primarily upon counsel's request for a Tui-Rodriguez instruction. Of course, whether the jury is engaged in due and thorough deliberation to support a Tui-Rodriguez instruction and whether there is manifest necessity to declare a mistrial are distinct legal questions. In fact, the Tui-Rodriguez charge is designed to urge the jury to reach a verdict, not to avoid one. Yes and no. Yes and no. And part of it is that you ask for the Tui-Rodriguez because it can force the mistrial, right? That I think they're being a little coy here, a little bit coy. And I mean, every case I cover, there's always people who are like, you're only covering one side. You're a fanboy. And the thing is like, I will say when I think that the defense is being a little too clever, if that makes sense, or if they're trying to hide the ball here. So, yeah. Here, defense counsel's request did not reflect any implicit concession that the jury was deadlocked on all counts, nor did they commit the defense to any position regarding whether the court should sua sponte declare a mistrial. Yeah, I mean, I would make the argument. I think it's not a bad argument. I just have some skepticism. Blind Kimberly says, we've had 6 inches of rain already here. Is that 6 inches by how a man measures it or how a woman measures it? Because those can be a very different 6 inches. Moving on. All right. Moreover, the trial court's characterization of the jury's final note as making it clear that the jurors would not consent to continuing their deliberations is belied by the case law cited in the court's order. The jury, so looking at Jenkins, where the jury similarly reported after a Tui charge, they felt strongly that there was no hope of progress and requested further instructions. The court responded by telling the jury, I cannot force you to continue deliberations unless you agree to continue deliberations, but then asking them to retire and decide whether further deliberations on the next day would be fruitful. The jury promptly reached a verdict. Okay. Yeah. All right. So this court held that the object of the statutory prohibition on sending the jury back without consent was fulfilled because the jury consented to continue their work. The jury's return of a verdict after sending their last note implicitly satisfied the statutory requirement of jury consent. Thus, another alternative to a mistrial, which the trial court did not consider in this case, would have been to inform the jury that it could not be required to continue deliberations without its consent, and B, ask that it retire to consider whether it was prepared to return any partial verdict. Okay. Yeah. Here, neither Ms. Reed nor her counsel were provided an opportunity to object to the declaration of a mistrial, as opposed to the appropriateness of a Tui-Rodriguez instruction. All of the cases cited by the trial court on this issue are readily distinguishable on that basis. For example, in Pellegrin, a witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held that the defense had an opportunity to object, given that the mistrial was declared after a voir dire of the witness and colloquy after the jury were cleared from the courtroom. Here, by contrast, the defense did not learn the contents of the jury note or the court's intention to declare a mistrial until the judge called the jury in and stated the declaration of mistrial on the record. Counsel was never shown the note from the jury. Okay. Fair enough. As the appeals court has explained in an analogous factual context, the suggestion that counsel should or could or should have immediately objected to the sua sponte declaration of a mistrial underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. The possibilities ahead, such as the appearance of a new prosecution witness, cannot be instantly calculated. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. So basically saying we couldn't declare a mistrial because we have to think about things, right? We have to decide. There's so many difficult questions here, and we can't just decide in the snap moment without consulting our client. So they say that the prosecution has not established its high burden, and therefore that it should be tossed. I'm going to skip over a little bit because a lot of this is very similar. I'm not denigrating it here. I'm just noting that we've covered all of this. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able, once and for all, to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. So, the Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some, but not all standalone counts. And this is the thing, is that there is a tactical consideration in asking for a mistrial or not in those circumstances, because it could have been that the jury was like, we were set to convict on murder, but we didn't know about the leaving the scene, right? That would have been a very different calculation. The defense is bringing this after they've learned what the jury was thinking, but it could have been a very different sort of scenario. So, yeah. Assuming arguendo, this court finds that counsel consented to the mistrial, the defendant's personal consent was required. So basically saying, listen, even though counsel may have consented by not standing up, she's got to give instructions. Karen Reed's got to stand up and has got to have, So they note that some basic trial choices, including the choices to plead guilty, waive a jury, testify in their own behalf, or take an appeal, are so important that an attorney must seek the client's consent in order to waive that right. So, the Supreme Court has recently shifted the balance of power between counsel and client regarding fundamental decision-making in criminal cases. See Hashimi. Assuming arguendo, the court finds that counsel consented to the mistrial here, the defense contends it should additionally address whether the decision to forego a jury verdict is among the fundamental questions that must be decided by the client, as urged by the defendant in the court below in this appeal. This argument, by the way, is why you hire a second lawyer for this. This is Martin G. Weinberg. Good on him. Martin G. Weinberg. This is the kind of argument of counsel might have consented, but they might have not, or done it without the client's instruction or permission. That one is an argument that I don't think you can make if you are counsel on the appeal as well as counsel at the trial. I don't think Jackson and Unetti can properly make that argument themselves, right? But Weinberg can. Weinberg can say, hey, maybe Jackson and Unetti fucked up. Trial court should have allowed that. I see somebody saying, please dumb down this argument. Basically, there's certain decisions that simply cannot be taken away from the client. So let's say I am sure, certain, 100% certain that my client committed the crime, right? And I'm sure that my client is gonna be convicted. And I think he'll get a better sentence by pleading guilty. I can't plead guilty on my client's behalf. I have to have instructions on that plea. I have to have instructions, right? I have to have instructions. Glass Mama, yes, it is appropriate to send auction items to the P.O. box. Please put a mention in it that it is for the auction, just so I'm sure that that's what it's for and that it's not for me. Because if something is intended as a personal gift, I feel like a jerk if I auction it. And similarly, if something is intended for an auction, I feel like a jerk if I keep it. So please let me know whether it's for the auction or for me. Yeah. All right. Breaking out one more pink lemonade. We are just wrapping up here. And all right. So basically the argument here is that this decision as to whether or not to poll the jury or to seek a mistrial is one of those fundamental decisions that requires not just the feelings of counsel, but that the accused be consulted. And the thing I will note here is that there are decisions that counsel can make on their own. There are decisions that counsel can make all on their own. So, for example, let's say they try to admit some hearsay, right? I can go ahead on my own. And just say like objection or no, right? That is within my power. I don't have to consult the client every time I want to object or not object. But if the client wants to plead guilty, even if I think they've got a great defense and that they should absolutely run this trial, the client 100% has the right to plead guilty, even though I think it's awful, right? I think it's awful. So, that, and that can't be taken away from the client. It just cannot. So based on that, that's the argument here, is basically that defense counsel, even if they consented, they didn't talk to their client, so it's not a valid consent and it doesn't mean shit. I don't think it's a terrible argument. That said, I think this is well written. I think this is cogent. I think it is very well argued. I think it's well researched. And I think it's a losing argument. And I hate that it is. I hate that I think that. I hate that that's my take on things. But I think that's where we are. I think that this is ultimately doomed to fail. And that is sad, right? That's just the nature of the profession sometimes, right? Is that you have things. Sometimes it doesn't matter how good you are. It's just you're still going to lose. And like, sucks to exist, really. I really wish we lived in a universe where Lolly would do the right thing and spike this case and just be like, fuck it, we tried, we didn't get anywhere, done. We don't live in that universe. They're trying extra hard. In fact, they're brought on a new prosecutor to help Lolly out, and Lord knows he needs it. Lord knows Lolly needs all the fucking help. And the reason why he needs all the fucking help is, did you see his opening statement? I watched his opening statement, all like 72 hours of it. I just don't know what his opening statement was or where it was going. It was like a complete family history of everyone who has ever, like, all of the baguettes in Canton. And I'm just like, why and it was snowing, and who's related to who and who's boning who on the side. And by the time they got to their the end of Lolly's opening statement, I had no fucking clue what their theory was. I had no clue what was happening, right? I was like, he said so many things, and he just kept talking and talking and talking. And then afterwards, he's done talking for forever. And you get Yannetti stands up and he's like, is this thing on? Is this thing on? Karen Reed was framed. And I was like, holy shit. Right? It was just like, wow. Okay. It was such a difference in opening statements. And yeah. Yeah. All right, let's cover some super chats here. Yeah, this is really, I wasn't planning on streaming the Karen Reed trial at all. I was not planning on it. Wasn't gonna do it. Wasn't gonna do it. And then I watched the opening. And the opening statements got me hooked. Because A, I wanted to mock Lolly's opening statement, and it's like 20 years of bullshit. And B, I wanted to, I just wanted to cover Jackson's, Yannetti's opening statement, because it was so good. All right, let's cover the super chats, and then I'm going to wrap this up and go to sleep, because it is 1 a.m. I have to be up in 7 hours. And before I go, can we get a hot sauce sales numbers update? Yes, we can. Hot sauce sales numbers. What is it? We have I'm just looking here. So there have been 36 orders comprising, I'm just trying to see how many products that is. So we started off with 65 and 66 hot sauces. We now have 34 and 24 left. So more than half of the sauce has been sold. And yeah, more than half, which is pretty awesome. Which is pretty cool. All right, let's do all of that. Galena Ward, is it free Karen Reed or fuck Karen Reed? It is free Karen Reed. That is what the FKR was standing for. AKA the Cat Lady. They've also charged several women with witness intimidation for meaning McAlberts. Felonies. Jesus. Winnie Bly, glad I'm not Bob. I'd be dead or bankrupt many times. I think we're all glad not to be living in a Runkle hypothetical. It's one of the worst places to live, folks. Lady Fang, comes now is the most annoying one for me. If I can end comes now, that will be amazing. That will be just amazing. Snoopykins, thank you for the 10 gifted memberships. Much appreciated. Lori Lenny, thank you for 5 gifted memberships. Slovak Girl, 94. Good morning from Slovakia. The best thing to wake up to, Ian's stream, though I know you need sleep, so always happy to rewatch. Well, thank you so much. I'm glad you could make it. Fifi is my name. Igloo Hug Hotel Fund. Well, thank you so much. VL, good morning from Finland. Heard our country mentioned, so obligatory Torilla. I hope I'm pronouncing that right. Fifi is my name. Thank you for 5 gifted memberships. Jackie Lindy, I know I send you a lot of emails. Do you want me to continue sending things I find interesting that might be good for Monday Law Day? Yes, absolutely. Thank you, Jackie. Lori Lenny, thank you for 5 gifted memberships. Much appreciated. And Dragon Star, thank you for 10 gifted memberships. All right. I am tired. Where do I live? Edmonton. Where do I live? Edmonton. Comes now, featuring adult star Miranda Warning. Oh man, if I ever get around to actually making that, I will have to get somebody doing the or somebody going as Miranda Warning. So yeah. All right. Let's sort of wrap this up. And yeah, it is 1 a.m. now. It is indeed. And then I will see you guys all soon. Maybe tomorrow. It depends on how bagged out I am tomorrow. So let's run the intro and see you guys next time. And hot sauces to start getting mailed tomorrow.